to one matter is the motion. My lord, this is about a vehicle location tracking device. You are the manufacturer. It is under the central lease, like speed meter. Like you put in commercial vehicle, you cannot go beyond 80. So there is a tracking. So this they have introduced because of Nirvaya case. Now this is a central legislation where you have to be approved from the testing agencies. Now what they have done is minor state has now floated the UI, putting some stringent norms that you have to be manufacturer. But here in the central legislation is not required. They have specifically mentioned, I'll show before this court, two writ petition and filed. So if it is not in time, can it be taken up tomorrow? Because I have to go. Otherwise, I know your lordship will say that today itself, can it be taken off tomorrow? It is not inconvenient to your lordship. I'm deeply obliged. Two writ petitions have been filed.
I have filed petition yesterday, my lord. The settlement of market, settlement of Mean Mahal, my lord. So later it will come for motion Friday, my lord. Urgent, my lord. On the other hand, my lord, item 10, my lord, matter has become infructuous with regard to settlement of market period has already over in 2024. Item 10.
Mr. B. Rahman, the legal counsel appearing on behalf of the petitioner submits that the petition has become infructuous in view of the fact that the settlement period is already over. Taking into account the above, the condition stands alone in the models, if any, stands. Let me know.
So for item number 23, it has become infructuous for him.
Why?
But you already they have got the bill.
Mr. Ardhar, the legal counsel appearing on behalf of the petitioner submits that the petitioner have already got the relief for which the petition was filed. Taking into account that the above, as there is no live cause of action, the petition stands closed as infructuous. In game orders with any stand.
Yeah, please, Lordship. Lordship, I beg to mention item number 22, Lordship. Kindly adjourn the matter for the day, Lordship. My senior Miss A. Gayan, her relative expired last night, Lordship.
Why?
Lordship, her relative expired last night, Lordship. Miss A. Gayan, Lordship.
You've informed the other side. No problem. Rest of the parties, the matter stands adjourned to be listed on 3rd of August 2026.
Lordship, can it be on 6th, Lordship?
No. It will be on 5th August.
Lordship, with the consent of the other side, I beg to mention item number 36.
Yes, tell me.
The leading counsel is having some personal difficulties, so we could not be.
Who?
Or Dr. Ankit Todi.
Well, who will be? The request of the parties, the matter stands adjourned to be listed on 7th of September 2026.
I beg to mention on matter, my lord, it was listed on 20th of March, my lord. Promotion, my lord. On that day, my lord, I could not appear, my lord. Then it was ordered adjourned for 2 weeks, my lord. Since then, it was not listed. So I pretty much it may be listed on 1st of June, man. 1st of June, man.
Need please, Lordship. I beg to mention for listing of a rate petition for tomorrow, Lordship.
Tomorrow?
The urgent matter, Lordship.
What is the matter? Motion?
For motion, fresh matter.
Day after, Friday.
Friday, okay. Friday.
Why tomorrow?
Lordship, the matter is related to settlement of a tender. The tender is already settled in the name of the respondent.
Then?
We are praying that the tender should be settled in the petition as well.
So what happens will fall from tomorrow to day after.
Day after will be so.
Day after. Moving to item number 58, admission matter.
For the petitioner, my lord, I have instruction to withdraw this petition.
Mr. A. Ganguly, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition. Taking into account the above, the petition therefore stands closed on withdrawal. Interim orders, if any instance, will keep it. Time for the respondent six, put your name, give it to them. Yeah, please. Miss Udas? This is for non-payment of dues. Give a copy. Give a copy now. Okay. Your non-payment of dues, you have admitted, and accordingly this court granted you 6 months to make the payment. Why no my payment made? Hmm?
I complete instruction.
Higher charge billed amounting to so is yet to be sanctioned from the Assam Police Headquarters, Ulubari. So
Lordship. Yes.
we have it on 8th of June.
Lordship.
Get your instructions. Why we should not otherwise issue contempt
Lordship.
or Mr. This is an application filed for alleging willful and deliberate violation to the order dated 17/10/2025, passed in WPC number 4073 of 2025. This court, by the said order, directed the respondents to make the payment of rupees 8,54,407 within a period of 6 months from the date a certified copy of the said order was served upon the Director General of Police, Gauhati, Government of Assam. The record further reveals that in pursuance to the order passed by this court on 17/10/2025, the certified copy of the order was served upon the respondent, upon the Director General of Police on 25/10/2025. 6 months have elapsed in the meantime, and as no payment has been made, the petitioner is constrained to approach this court by filing the present application. Ms. Udas, this court have requested Ms. Udas, the learned additional senior government advocate, who was also representing the respondents in WPC number 4073 of 2025, to inquire with the respondents and more particularly the Office of the Director General of Police, Assam, as to why the order dated 17/10/2025 have not yet been complied with. And a copy, Mr. A.K. Hussain, the learned counsel appearing on behalf of the petitioner, is directed to furnish a copy of the present order to a copy of the present of the instant application to Miss Yudas, the learned additional senior government advocate, to obtain instructions. Miss so-and-so, the name of Miss Yudas, the learned additional senior government advocate, be reflected in the cause list. List the matter on 8/6/2026.
Clearly submit, because of typographical mistake, well, it is, we have type in the our paragraph 8684, So amount is, as per the order, amount is 854,407. But in the petition, we have typographical mistake,
I put it as per the judgment order.
Yes, according to the.
I have
but
not
in-
put it any other amount. The
Mile.
amount which I have.
Mile,
put
mile,
is-
mile. But in the petition, we have.
No,
stated-
we have
That
put
is
the
why
amount
clearly
at
submitted.
rupees 8,54,407.
Mile,
I don't go as per what you.
mile. But the second is also same, amount is,
Same order.
amount is 9997.
Value. You give the copy to the.
287.
May I do the motion?
Lordship, in this case, after filing of this writ petition, there is some development in this case. So actually yesterday, the respondent number 3 issued a letter to the petitioner. This is the copy of the letter.
Lordship, I have received the instruction from the DTO, Lordship.
Actually,
Lordship, I dispose to this matter,
they're supposed to issue the convert the digital manual based driving license to digital one yesterday, but due to some technical issues, they couldn't complete the process. So may-
So your case is for conversion.
yes,
So you have been asked to appear. So there is nothing in it.
Nothing,
may I
sir.
pray that only 2 weeks, after 2 weeks.
No, Lordship, I dispose of the matter. I will-
No,
Matter you withdraw with liberty
Yes.
in view of this letter. We keep it on record, this
yes,
letter.
yes, okay.
That is enough.
Yes, yes.
That is a stand being taken. So
Yes.
nothing remains
Without liberty, yes.
with liberty. Or Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so
Okay, I'm
appears on
going to
behalf
one
of
in-
respondent numbers 1, 2, 3.
She Lordship BTC, but DTO has written to me.
Huh?
She is the BTC, under BTC, but the DTO has written to me.
DTO, no, you, BTP will not help in. The present petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authority in converting the offline driving license of the petitioner to digital driving license. Poster. Ms. Andy Bora, the learned counsel who appears on behalf of the respondent numbers 1, 2, and 3 submits that the petitioner had been asked to appear before the respondent number 3 along with all necessary documents so that the offline driving license of the petitioner can be converted to digital driving license. In that regard, the learned counsel, standing counsel have also placed before this court an instruction dated 19 May 2026, which is kept on record and marked with the letter X. The learned counsel appearing on behalf of the petitioner submits that taking into account the submissions so made by the learned standing counsel of the Transport Department, as well as the document which is kept on record and marked with the letter X, that the petitioner would be well advised not to further pursue the instant proceedings. He, however, submits that in the circumstance, upon in the circumstance, the digital driving license is not issued to the petitioner. The petitioner may be granted the liberty to again approach this court. Taking into account the above, the petition stands closed on withdrawal. Liberty, however, is given to the petitioner. In the circumstance, the petitioner is aggrieved by the inaction to convert the offline digital license to or driving license to the digital driving license. If so, Sanofi, what? What is Sanofi?
Lordship, before placing the case, Lordship,
Sanofi makes what?
okay,
Diabetic drugs.
Lordship,
What is the matter
medicine
about?
company, Lordship.
Huh?
It's a medicine company, Lordship. Medicine company, Lordship.
I know that.
Lordship, before starting, Lordship,
What is the matter?
what happened? One page, Lordship, is missing. Okay, it's an award. I've challenged the award of the London Labour Court. Lordship, page 86. If your Lordship goes to page 86,
Yes.
it is internal page 10 of the award, and Lordship, internal page 11, Lordship.
Hmm?
Internal page 11 is not there, Lordship.
Oh, 11 is not there.
Lordship.
What is the
My
award?
learned friend is on caveat. He has a copy of the same. My learned friend is on caveat, Lordship. He has a copy of the same.
What is the award?
Lordship, award is reinstatement with full back wages, Lordship.
Why? What is your problem?
What happened, the Labour Court came to the finding that there is no inquiry. So
No domestic inquiry.
no domestic inquiry,
And you have been terminated.
Lordship.
Now, therefore, did you adduce any evidence?
Lordship.
What happened?
It is a petition under 2A, Lordship. The workman laid the evidence first because it was his, but then we also laid evidence, Lordship. That those evidence were not taken into consideration. Only if your
So
Lordship
he has not decided
is not decided, Lordship.
that you see, a person can be very well terminated
Lordship.
without an inquiry also.
Lordship.
There's no quarrel with that. But then you have to support your action by way of evidence.
Lordship. We have
That's the case.
laid evidence on merit, Lordship.
And where he has not looked into it.
We have not looked into it, Lordship. If your Lordship
Where?
read Lordship page 11, internal page 11, Lordship of the award, just supplied.
Now let us see issue number 1. The management also has not reduced the evidence of the inquiry officer as a witness in those cases who have conducted the inquiry to prove the authenticity of the inquiry held and authenticity of the signature. From the above, it can be held that the veracity or authenticity of the contents of the evidence of the year remains contradictory in absence of the effective witness and management. Now, because it is a laid down, the departmental inquiry.
Garnet Labour could consider the matter as retrenchment lawful. 25 I have not sure.
Where we got this aspect? Finally come to internal page 9.
9 lordship.
How does the labor code come into this system? A departmental inquiry for terminating and involves a structure in all this.
Lordship, nowhere in the pleadings.
So there he must have used the AI.
Lordship, nowhere in the, neither
Huh?
he has pleaded, neither I have pleaded, lordship. So,
Anyways, and the banquets. My priority on perusal of the entire record, it reveals the department though had issued a photo to the Western on so but has not reviewed any document before it spoke it shows the document charges.
For the labor court lordship, the respondent number 2 filed an application under 36 lordship, regarding appearance of the lawyer before the labor court on behalf of the manager.
Okay. We stay
No.
subject to payment of last on weeks.
Lordship, they may file an application under affidavit under 17B.
Then no stay. You file it.
No, no,
File that.
I'll pay loss.
But one important question arises as to whether he is a workman.
But that,
I serious doubt whether he is a workman.
No, my lord, under section 2S, it is subsequently amended in 2007, some amendment is there. The sales promotion employees as defined under section Sales Promotion Employees Conditions of Service Act, as per section 2D. Sales promotion employees are termed as workmen under section 2S. It is 2007 amendment is there. Industrial Disputes Act, Assam amendment is there. Yes.
How do we find it? You have it?
Section 2, yes. Section 2S, my lord, Industrial Disputes Act.
You notice making a return of the 5th of August 2026. You are appearing
Employee appeared for the respondent number one. Mr. So-and-so, who appeared on TV. Mr. So-and-so, Mr. K.M. Lloyd, the learned counsel, appears on KVL or for the respondent number two. The petitioner herein have challenged the award dated 18/2/2026 passed by the Learned Labour Court of Assam, Kamrup, Metro at Gauhati, whereby in the proceedings initiated under Section 2A, capital A, of the Industrial Disputes Act 1947, the Learned Labour Court held that the termination of the respondent number two was illegal and accordingly directed reinstatement with full back wages. The learned counsel appearing on behalf of the petitioner submitted that the only reason for deciding the said reference in favor of the said proceedings in favor of the workman was on account of not holding a domestic inquiry or only upon coming to a finding that there was no departmental proceedings of the domestic inquiry held against the respondent number two. The learned counsel submits that not holding a departmental inquiry of the domestic inquiry cannot be a ground to allow the said application if evidence have been left by the management showing the misconduct of the respondent number one or the respondent number two. The learned counsel further submitted that the respondent number two the learned counsel further submitted that a perusal of the entire award would show that this aspect was not at all taken into consideration. And under such circumstances, the action on the impugned award suffers from perversity and accordingly liable to be interfered with. Per contra, Mr. K.M. Lloyd, the learned counsel appearing on behalf of the respondent number two, submitted that the award not only the award not only takes into consideration the evidence, but there was no effective evidence placed which would have justified the alleged misconduct upon the respondent number two. He therefore submitted that the Learned Labour Court had duly considered all the material facts at the time of arriving at the opinion by the impugned award. This court, having heard the learned counsel, is of the opinion that the learned counsel appearing on behalf of the petitioner further submits that the impugned award be stayed, taking into account that the award directs reinstatement with full back wages. So this court, having perused the impugned award, is of the opinion that the petitioner has been able to make out a prima facie case. However, it is also the requirement of law that it is also seen that the respondent number two have been reinstated with full back wages. Under such circumstances, this court stays the impugned award dated 18/2/2026, subject to the petitioner making payment of the petition to the respondent Number two, the last drawn wages. This code also directs the respondent number two to bring on record their stand by filing affidavit. And in addition, in the said affidavit, the respondent number two shall also indicate as to whether the respondent number two is presently gainfully employed.
Much.
Records for registration take effective steps that the records are available before this court opens.
Chief directed me to take instruction, my lord. Lordship directed me to take instruction from the, my lord, Secretary, Commissioner Secretary of Government of Assam Tourism Department, my lord. I have received the instruction, my lord. Stand of the exhibition has also been mentioned, my lord.
He did what? What Department of Housing
and urban affairs.
Urban Affairs? What did that do with this?
On Department of Housing Affairs controls the GMC, GMBA, Smart City, and other. With the parent department.
So madam, you couldn't find the ATBCL. Why the managing director could not instruct the council to appear on the, are you appearing for it?
Yes, fine.
In the costly, I have seen my lot here, they find the color. In the,
Where is she?
they are in the costly city.
I had specifically mentioned the council for another matter. I told him they would present in this matter. Not done. I think it is the fault of the ATDCL. So we stay whatever action. Don't do anything.
This is property of the, now the property of the GMBA.
You do one thing, you close down the park. Park you have opened it, people have enjoyed, now I think close it down. When you could not get the ATDCL council or the managing director had no, could not do it. No. Let the managing director suffer.
Now it is the property of the GMBA.
There is nothing about the fact remains ATDCL claims the lease that it is their land. You have not made it clear. So therefore, how will the GMBA have an authority when ATDCL says that it is their land?
No, no, no.
Unless you say that the ATDCL have committed fraud, that you are not saying.
Lordship takes up a minute, dated. That minute.
Your mind is different.
The serial number 4.
No, you see, ATDCL would not come under the Department of Housing and Urban Affairs. No. ATDCL's existence is on the basis of the tourism department. Isn't it? You have different departments. So therefore, and your government has appointed, have made various, opened up various fronts. Today, ATDCL, today, ASTC, the other is there. And all these instrumentalities are there. So they, the problem is ATDCL always converges with the departments. This is not the only case. There are many other cases. That day, another case which I have taken up where ATDCL is doing, and at last the chief secretary of SAM has been directed to submit a report. This is what is happening. So here ATDCL by way of an agreement categorically says that it is their land. If it is their land, GMD has no business. Unless, how? How it is being taken over? If you see, ATDCL is the corporation. A corporation's land cannot be taken over by any other department because it is an entity on itself. So you cannot do anything. Close down. Give it to him. Give it to him. Hand over the possession of how much? 6 patas.
6 cut.
6 patas.
66 bigas, sorry.
Measure it out. 2,440 into 6. 1/6 bigas.
Yes, ma'am.
Give it to him.
For that, there is an arbitration clause. For
No.
that,
Give it to him.
And
Who are you? Who are you?
No, these are
Give
GMD.
that land back.
It is the GMD which is challenging that particular.
You do
particular
whatever
activity.
may be, but you carry out, GMD may carry out anything. I'm not concerned, but the GMD cannot carry out the lease or that NIT in respect to that area of land which falls within the lease. Because there was a promise being given. ATDCL. ATDCL still owns the land. ATDCL has not come up before this court when I have specifically mentioned. Now, therefore, I am constrained to issue a notice. Once I have issued a notice, if I don't stay, it makes no sense. So therefore, I have to stay whatever may be. You go and enjoy that.
And only that
Can't help it.
EMD notice.
Don't know. You have no business. GMDA may have many other things. Where is the power out there to GMDA to hold the land? Show me.
That minute, my lord.
No, minutes cannot be. A
That-
power has to be on the basis of a statute. Where is the statutory provision that GMDA is the owner of this land?
That minute, subsequently that it had been transferred to GMD.
Where?
That instruction, my lord.
Who has transferred? How a land belonging to ATGCL? You see, therefore my question is, that day I was about to dismiss, but the moment I saw the schedule, the moment I saw the schedule, then we cannot have it. See, all the piece and parcel of the riverfront and so, that is the property of ATDCL, situated at Udan Bazar over a plot of land over 6 bighas within the jurisdiction of the Gauhati in so, which is butted by North Brahmaputra River, South Road, East Luis Gate, West Kosari Bazar. So, within these 6 bighas, you can't do anything. You go on to JMDL, let whatever may they, or 5 and 6 may do whatever they may. No.
Page 60
And
also.
it is the fault, madam, of the ATDCL. I can't help it. The ATDCL council did not appear.
I will inform them.
Can't help it.
Page
I told you on that day only. I told you. The problem is because of the ATDCL council. Therefore, I asked her, kindly inform the managing director to take it up with them. You did not do it. Rather, the managing director thought, better let me put her all right on here. So this aspect has to be brought by way of an affidavit. I can't take this because he has an opportunity. So therefore, it is because of the inefficiency of the departments this has happened. And now I'm compelled to issue a notice. Sorry, I'll help you.
Page 60.
Issue notice making, we'll have it in the month of December. In the meantime, you can very well, in the winters, you can do it. We stay with the month of December. In the meantime, you can take a it up, give him the 6 bighas of land. Thereafter, you do.
But that 6 bighas may there is arbitration clause. They have an agreement with ATDCL. That's right.
ATDCL has no problem. ATDCL has not come up before this court today.
It is a penal sir. 57, my lord. That
Madam, Mr. Bora, kindly appreciate. ATDCL has not come up before this court. I am yet to issue notice. So ATDCL, I gave an opportunity that was not availed. Can't have it. Issue notice making it returnable on 24th of June 2026. Miss Ludas appears on behalf of the respondent number 1. Mr. Espora appears on behalf of the respondent number 5 and 6. Extra copies of the writ petition be furnished during the course of the day. Insofar as the respondent number 2, 3, and 4, petitioner shall take steps by way of speed post by tomorrow. Further to that, the petitioner is also directed to effect service upon the respondent numbers 2, 3, and 4 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner should ensure that the service by way of dusty is meted up upon the respondent number 2, 3, and 4 on or before 8th of June 2026. The petitioner herein is aggrieved by the action on the part of the respondent number 6 to float a tender in respect to a plot of land. Where is the tender?
Tender is case
87.
Each. It agreed by the actions on the part of the respondent number 6 to issue a notice inviting request for proposal bracket RFP dated 17/1/2026. Mr. Council, why have we challenged it now?
because my lord,
After so many years.
no, my lord, 17/1/2026.
So therefore, we are after 6 months, 4 months.
Yeah, my lord.
না forget about তো এখন returnable জলদি করি returnable on returnable on 8th of June 2000 no returnable on 1st of June 2026. Does the effect to be given on or before the next date upon response number 3, 4, and 5? Does to be served on or before 28th of June, May 2026.
Well, may I point out one thing? Well, in page number 40, the earlier NIT matter, where here petitioner has got the.
I'm not granting a stay because he has come so late.
My lord, my humble submission,
No, I can't. Therefore, I'm having it on 1st of June. I'm having it on 1st of June. I'm not having it on 20. No, the fact that you have approached this court so late, I can't.
because in clause
Petitioner hearing is agreed by the action on the part of the respondent number 6 for issuance of a notice inviting request for proposal bracket RFP dated 17/1/2026, whereby entrepreneurs of the firm were invited for leasing of space to set up restaurant of the cafeteria in Sati Radhika Hanti Udhayan Park at Ujan Bazar, Gauhati, Block 1. It is the specific case of the petitioner that the said park was leased out to the petitioner by a development of a management and operation agreement entered into by and between the petitioner and the respondent number 2. The learned counsel, Mr. N.N.B. Chaudhary, the learned senior counsel appearing on behalf of the petitioner, had submitted that the petitioner was permitted to run the said was entrusted with the development, management, and operation of the Sati, what is that name?
Satyatika Shanti Uddan.
The so and so. For a period of 5 years from the date of the said agreement dated 5th of January 2022. The learned counsel, senior counsel further submitted that on account of certain beautification to be carried out in the riverfront. The petitioner was asked to vacate the area wherein the possession was granted to the petitioner on the basis of the agreement dated 5/1/2022. The petitioner vacated the said area upon an assurance being given by the respondent number 3 that the petitioner would be handed back the area which was a part of, which was allotted to the petitioner on the basis of the agreement dated 5/1/2022. It is the further case of the petitioner that thereupon constructions were carried out. Upon completion of the construction, the petitioner was surprised to see the communication, the notice inviting request for proposal of the area which have been, in respect of which the petitioner was granted rights on the basis of the agreement dated 5/1/2022. The petitioner thereupon filed applications under the Right to Information Act. Upon information being provided,
The information was not provided.
upon information being not provided, the petitioner has been compelled to approach this court. The learned counsel appearing on behalf of the petitioner submits that the petitioner not only have rights over the said area of the land which formed the basis of the agreement dated 5/1/2022. Inasmuch as the petitioner not only was granted rights in terms with the said agreement, but the petitioner had invested on the development of the said park. The learned counsel therefore submitted that this is not a case which is not a case of a breach of an agreement simpliciter, but also a case wherein the doctrine of promissory estoppel duly applies. Mr. Esbora, the learned standing counsel appearing on behalf of the respondent number 5 and 6 submits that the petitioner that the instant petition ought not to be entertained, taking into account that the agreement dated 5/1/2022 contains an arbitration clause. Replying to the said submission, Mr. N.N.B. Chaudhary, the learned senior counsel, submitted that there is no dispute between the petitioner and the respondent number 2, 3, and 4. The action which have constrained the petitioner to approach this court is on account of the respondent number 5 and 6, who are not privy to the agreement dated 5/1/2022. He therefore submits that as the respondent number 5 and 6 are not party to the said agreement or do not claim any right on the base from the ATDC from the respondent number 2, the question of approaching the arbitration form does not arise. Going for approaching the for going ahead with an arbitration does not arise. This court have given an anxious consideration to the respective submissions, and it is the opinion of this court that the petitioner has been able to make out a prima facie case. First, it is also a prima facie case for grant of certain interim directions. Accordingly, this court directs that till the next date, a status quo be maintained as regards the Sati Radhika Hanti Udhayan, as regards granting of any lease or allotment in respect to Sati Radhika Hanti Udhayan, and more particularly of the area which is specifically described in Schedule A of the agreement dated so and so. The respondents herein are directed to bring on record the stand by filing the affidavits on or before the next date. It is made clear. This court, however, clarified that taking into account the riverfront area is a huge area, and encompasses, and taking into account that the riverfront, Brahmaputra riverfront area is a huge area which encompasses not only the area which was wherein rights were conferred upon the petitioner, as described in Schedule A to the agreement dated here, the respondent authority shall not have, however, the interim order passed herein above shall not affect the rights of the respondent authorities to grant any lease in the remaining areas.
May I please, Your Lordship?
Yes.
Your Lordship, as per the order, Lozima Court order dated 14/5/2026, the services upon respondent number 4 are completed.
Oh, complete.
Yes, Your Lordship.
Service complete. What is your matter about?
Your Lordship, here the petitioner is a RCC building owner and the respondent number 4 is the mason working, claimed to be work under the
challenging-
construction for the.
Judgment in order to under the Payment of Wages Act. Okay. The service is complete. Let us. Who are you?
I am for the petitioner, Your Lordship, on behalf of Mr. N.
That I know. Who are you otherwise?
Sir,
the-
sir, I am the
You are
party number 2,
you are the employer or employee?
employer.
Employer. So what has happened? What order is this?
So basically happened is this, the respondent number 4 is a mason worker who claimed that he has worked for the petitioner, current petitioner for for building a RCC building in the year 2013 and 14, for which the amount wages is 1,40,600. He also stated that the petitioner also paid a little amount of 64,000 and remaining amount of 76,600 is still to be paid.
So there was an amicable settlement.
No, Your Lordship, there is no amicable settlement.
So there was a period the report, case record, and it is observed that initially the first to so and so submitted a claim petition to the labor inspector for realization of the demand. And if the matter of non-payment could not be settled immediately. So there is no application of mine.
No,
That's the case.
They said no evidence was adduced before passing this.
No,
order.
here, you see the order, there is no application of mine. Only see page 14.
Yes, Lord.
The opposite party submitted his written statement where he denied the allegation and claim made against him by the first party, so and so. as the matter of non-payment could not be settled immediately at the level of insurance, the matter was referred to the appropriate under the aforesaid law. In view of the above, so and so, in my capacity under the year, do hereby direct. What is this? And we peruse the record of which is absent. Thus the case is referred to the passing ground for recovery. So this is a subsequent order.
Subsequent order, main,
Hello. Heard, Miss, we allow your petition. Heard, Miss so-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.R. Bulwa appears on behalf of the respondent numbers
1, 2, and 3.
1, 2, and 3. None appears on behalf of the respondent number 4, in spite of the service being complete. The petitioner herein have assailed the order dated 28/8/2017 passed by the Learned Additional Deputy Commissioner of Town Authority under the Payment of Wages Act, Hailakandi, whereby the petitioner was directed to deposit an amount of ₹76,000, whereby directed to deposit an amount of ₹76,600 within a period of 45 days from the date of the said order. The petitioner has also assailed the consequential order dated 29/1/2018, whereby the Tahsildar was directed to recover the amount of ₹76,600 in the form of land revenue from the petitioner. The learned counsel appearing on behalf of the petitioner submits that a perusal of the impugned order would show that the authority did not assign any reasons in the said order, merely on the ground that there was no amicable settlement. The authority came to a finding that the petitioner was liable to make the payment of ₹76,600. It is the further submission of the learned counsel appearing on behalf of the petitioner that when the authority have been entrusted with a duty and obligation to decide, it is incumbent upon the authority to assign reasons, and failure to assign reasons would be construed that such action or order to be unreasonable, arbitrary, and accordingly in violation to Article 14 of the Constitution. Mr. S.R. Bulwa, appearing on behalf of the respondent number 1, 2, and 3, submits that a perusal of the impugned order dated so and so also appears to be would show that there is no reasons assigned why the amount of ₹76,600 have been held that the petitioner was liable to pay. He, however, submitted that if these dues are payable by the petitioner to the respondent number 4, the respondent number 4 should not be deprived of the said amount on the ground that there was a mistake committed by the authority in passing the impugned order in the fashion it should have passed. This would have done it, heard the learned counsels appearing on behalf of the parties and have given an anxious consideration. A perusal of the impugned order would show that there is no reasons assigned. It only shows that upon the amicable settlement being not reached, there was a direction passed upon the petitioner to pay the amount of ₹76,600. It was the duty a duty was cast upon the authority to decide as to why the amount of rupees 76,600 is payable by the petitioner. Full stop. The same having not been done, the impugned order suffers from is unreasonable, and accordingly, the impugned order is set aside, and impugned order dated so and so is set aside and quashed. First, the order dated 29/1/2018, being consequential to the impugned order dated 28/8/2017, is also cannot withstand the scrutiny of law. Accordingly, the writ petition stands disposed of with the following observations and directions. The impugned order dated 28/8/2017 passed by the additional deputy commissioner, Town Authority under the Payment of Wages Act 1936, Hailakandi, as well as the consequential order dated 29/1/2018 in case number 20M/2014 are set aside and quashed. Number two, the additional the issue as to whether the respondent number 5 is entitled to the amount as claimed in his application is remitted back to the authority under the Payment of Wages Act in the district of Hailakandi. Now Hailakandi, Sri Bhumi.
Hailakandi is
Hailakandi. Yes, Karimganj.
Karimganj is the home.
Hailakandi.
And please respond number
Who's-
4 also.
Huh?
Respond number 4, last
Respond
line.
number 4. Remitted back to the authority, remitted back to the respondent number 2 for a fresh decision on the application so filed by the respondent number 4 in case number 20M/2014, taking into account that the said application has been pending for the last more than a decade, the respondent number 2 shall take effective steps for disposal of the same by giving a hearing to both the petitioner and the respondent number 4. With above the instances, proceedings to be completed within 6 months. Mr. S.R. Burwa, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 shall intimate the respondent number 2 about the order. A copy of the said order is furnished. The registry shall furnish a copy of this order to Mr. S.R. Burwa for the needful compliance. But they will not inform.
Definitely,
What is this?
Lordship,
6 and 7, neither AD card or unserved notice till date in connection with notice dated. However, the track consignment reflects the item delivered to respond. Who appears for respond number 3? The service is complete. What is your matter about?
this is about the one-stop center, Lordship, wherein the petitioner has, wherein his bid was ordered that it's non-responsive and immediate on as per annexure 3, Lordship, page 51, which he has raised 26 of August 2021, Lordship. Non-responsive and immediately,
So the tender has been given to respond number 3.
yes,
Where is he? Not far off. He's very nearby to Bomb
Yes,
Green.
Lordship. And
Take service by way of the school. Taking into account the service by way of
Otherwise, my lord, this has already been probably infracted because
Huh?
it's granted to 2021. Lordship, our nature is
Has the work been completed?
No, running.
What the work was?
The work is one-stop center, running of 181 helpline number, Lordship.
181 helpline. Where?
In, from 2017,
The period is what?
petitioner was
Well, the period of, period for the contract?
is 20 of our affidavit annexure 9. Work order, madam. It was for 21, 22.
Wait. Next one, page 20.
In internal page 20 of the affidavit, madam, annexure 9, lordship will find order, work order for supply management. We need 21.
What is the period?
Lordship will find in the subject, my lord, the order dated 6th of September 2021. To my lord, then subject.
2021-22. What remains?
Nothing now.
That is why nobody is appearing. What are it? And what is the other one?
One also, my lord.
Other one is one clause we have challenged, Lordship, wherein petitioner's organization is registered in Delhi. And they were running since 2017 and they run across in Jammu and Kashmir, even in Meghalaya, one-stop center. And one of the clause in that, Lordship, which debars them from applying. But this clause remains, so which debars the petitioner trust to apply.
Has
Subsequently,
the contract been given?
yes, Lord.
Work order finished? Huh? Nothing.
Remaining till some of the.
Madam Bose, we
Because
are
of
not
40
going
minutes.
to, I don't think the court has the luxury to deal with those matters which have already died its death. We'll consider other matters. Heard Ms. D. host the legal counsel appearing on behalf of the petitioner and 4826. Ms. Huda appears on behalf of the respondent number 1 and 2. The petitioner herein have essayed the selection of the selection. Your bid has been rejected.
Yes, Lord, sure.
The
Page 51,
rejection
Lord.
of the petitioner's bid by the respondent number 2 as non-responsive. It is however relevant to take note of that in pursuance to the the tender in question was only for a limited for a period of 2000 limited for the period of 1 year from 2021 to 22. And this aspect will be apparent from the work order dated
6th of September.
6th of
September, page 20.
6th of September 2021,
20.
where-
Page
whereby the period of the contract is for from 2021 to 22. Under such circumstances, as the contract is no longer there with the respondent number 3 on the basis of the tender wherein the petitioner was held to be technically non-responsive, nothing further remains in the instant, no live cause of action remains in the instant proceedings. For exercising the jurisdiction under Article 2 to 6 of the Constitution for which the writ petition stands closed. Continue. Heard Ms. D. goes to the counsel appearing on behalf of the petitioner. Ms. Hudas appears on behalf of the learned respondent numbers
My lord,
2, 3, 4, 5, 6. The
7.
1411. The petitioner herein have challenged a term of a notice inviting tender. Clause A of the notice of the model form of notice inviting tender for proposals by letter dated 16/7/2021. On the ground that the said, where clause 1? On the ground that the said
Page 88, Lordship, annexure 4.
said term is restrictive,
Page 88.
where 88
Yes, Lordship.
the it is relevant to take note of. That the said notice inviting request for proposal was for, was in respect of inviting experienced and registered agency to partner with the government of Assam to manage one-stop center in the district of Lakhimpur, Assam. Pursuant to the filing of the present petition, the learned coordinate bench of this court by an order dated 4/9/2021 issued notice but there was no stay granted. In the meantime, affidavit has been filed by the respondents stating inter alia that the notice inviting tender is based upon the implementation guidelines of the one-stop center scheme announced by the Ministry of Women and Child Development, Government of India in the month of December 2017. It is also brought to the attention of this court that in the meantime, on the basis of the said notice inviting proposals, persons have already been granted, no?
My lord, probably, it is not clearly stated here, but my lord, she has no claim, my lord, that she has to get it, my lord.
Appropriate partners have already been chosen to partner with the government to manage the one-stop center
But
in the various districts of Assam. It is also seen that none of these partners who have been selected have been made a party to the instant proceedings. Under such circumstances, the instant petition cannot be proceeded with, for which the petition stands dismissed.
on that,
24, the no etiquette or answer notice received there. But the step was taken by speed post. There is no etiquette. Yeah, speed post. I think there must be a report from the direct report. You have to get 65 lakhs. My lord, you've not got it. Not got it, my lord. In the PNRD has already deposited before the distribution. But subsequently, my lord, the earlier deputy commissioner filed an affidavit and said that no such amount was deposited in the account, my lord. It is disputed. No amount was, my lord, deposited. Who is the counsel for the PNRD? Their names have been shown in the court list. Render affidavit filed on 4/2/26 my lord, by the, on behalf of the commissioner, my lord. There are a series of communication is there, my lord. Page number 127 onwards. The communications are there. The communication is by the 25 page number 131. It is mentioned that out of the 21 schemes, my lord, 14 schemes, the materials are found, my lord, delivered. And according to my lord, the amount was, my lord, asked for from the district, and with 134, my lord, the amount of the 14 schemes were given by the, my lord, district authority.
One has appeared on behalf of the respondents when the matter is called for. Considering the above, one has appeared on behalf of the respondent. You are appearing.
Number 8. I'm appealing for one.
Now tell me whether you have released the fund to the deputy commissioner or not.
There's the one. We have already sent a letter to the director. We have 276. Yes, fine.
You carried out any inquiry?
No, no, it's a bit. So we're waiting for the inquiry report from the district commissioner, come DPC. Or complain, or submit the complaints report, but they do not submit the complaints report till now, DPC. So for that purpose, we have already sent a letter to the director of the Ministry of Rural Development, Government of India.
When the order passed by this court? Page number 6. Of the contempt petition. Huh? Page number 6 is the contempt petition, 11, page number 9 is the direction, madam. Page 9 of the contempt. Now tell me, let us not go into too much. The direction was for the panchayat and area to carry out the verification as to whether the petitioner is entitled to the lease. They will carry it out. Page number 131. 131. 131. Letter of that.
District commissioner.
Second paragraph.
25.
Have you carried out that? My question is simple. Have you
Not-
actually verify as to whether the petitioner is entitled to the 76 lakhs on?
Verified. Deputy Deputy Commissioner DPC is the main person to verify the amount.
No, I'm not there. Not on female.
But as per this 131, my lord, there,
Wait.
after verification, my lord, it is found that out of 21 14 schemes, they have received the materials, my lord. And accordingly, the amount was asked for, my lord. What will be the amount? And page 134, my lord, the amount is also mentioned, my lord. Of the 14 schemes, my lord.
There is no dispute about the receipt of the material for the 14 scheme out of one.
It is being given by the block development officer.
Lot.
It was given on 25/5/2025. My question therefore is, I have directed specifically the Commissioner Panchayat and Rural Development to carry out the verification.
Verification has.
Because the block development officer earlier also, when I passed the order, categorically stated, admitted that the petitioner is entitled to that amount. So therefore, my question, I directed the commissioner to make the verification. Has the commissioner made the verification? I'm not asking the commissioner to make the payment. He will carry out the verification. Payment we will look into.
Not the bit not done. Verification by
Well,
the.
Why that simple aspect have not been done? You are making a thing which is otherwise very complicated. Earlier, Mr. S. Gupta appeared before this court once and said that we have already deposited 65 lakhs to the Discrepancy. What is this?
Lordship.
The action of the standing counsel of the PNR department is not satisfactory. Either the action of the commissioner of Contract and now, heard Mr. So-and-so of the learning council appearing on behalf of the commission. Or I appeals for the responsibility. The present contempt application arises out of an order passed by this court, order dated 23/8/2023, passed by this court in WPC number 4511 of 2021. A perusal of the said order reveals that the petitioner approached this court by filing the petition claiming an amount of which 76,18,804 was payable to the petitioner. The said aspect, the said claim of the petitioner was based upon about the admission made by the block development officer Borkala. Be that as it may, this court directed the Commissioner Panchayat and Rural Development Department to carry out a verification as to whether the petitioner is entitled to the amount of rupees 76,18,804, which was certified as the amount payable to the petitioner by the block development of the block Borkala. This court have duly perused the various pleadings by their respective respondents. But the most pertinent aspect as to whether the petitioner is entitled to rupees 76,18,804 or any other amount in respect to the work carried out by the petitioner is not mentioned in any of the affidavits filed by the respondents. Considering the above, this court fixes this matter again on 15th of June 2026. The Commissioner PNRD is directed to submit a report as to whether a verification has been carried out as regards the entitlement of the amount. And if so, whether the petitioner is entitled to any amount. This report be submitted by way of an affidavit to be filed by the Commissioner PNRD on or before 12th of June 2026. Ms. N. Bora, who appears on behalf of the respondent number one, shall ensure that the Commissioner PNRD shall do the needful. We come up with that. We see later on. You are saying that somebody has to pay, some not, there's some fraud being committed, some work's not being done. We are not concerned as to whether he's entitled to this or any other. If he's not entitled, matter is that so much. Then I'm putting to asking to go before the civil court. That's you can't keep on doing all this.
Noted, and has already sanctioned. So, under process within 1 month will.
Huh?
And has already sanctioned, not so.
Action taken before. What is the order?
Order page package.
Paid?
Page package 6 months. Operating part under page 38, paragraph 9, 6 of 1.
So there is a direction as to whether the petitioner is entitled to any amount, and if so, to make the payment within 6 months. That's the order at page 36. Now, what has happened in the meantime?
But if it's under process, and fund has already sanctioned.
One sanction
That's,
of rupees 9 lakhs.
that's, so within 1 month will.
How much? Means within one, the amount is how much? 9 lakhs.
That's enough.
In compliance with the High Court's order dated so the material bills in so for admitted amount of rupees so in one during the time. So pending materials so and
That's,
what is your instruction? Direction was to whom? On the responding authority. But How much the petitioner is entitled to? 22. That is not clear.
Not clear, but
I think, why are you appearing in this matter? Because this court requested you. Huh? We do one thing, we dispense with the appearance. Not helping you. Dispense with your appearance. You have to appear with on the. Adis Puspanjali Das is the secretary. He's the secretary, na? And Ekka, I don't think. Why haven't you made the commissioner PNRD a party? Yeah. You have to get the money from whom? It is to be, it's not from district authority. But this is. Who is to make the payment? Four, my lord. Huh? Chief Executive Officer, that's one about 4 months. Who awarded the contract to you? And we are looking paragraph 7, my lord, this check, that side. We completed the period of. Okay. Chief Executive Officer, na? Now whether this person is still there? Or not there?
not also this.
He's not there.
No, he's not. No,
Miss Enbora appearing on behalf of the PNRD department submitted that the respondent number 2 as well as the respondent number 4. Respondent number 2, 3 also must be different now. Respondent number 2 and respondent number 4. To her instruction is no longer the holding the office as the principal secretary to the government of Assam Panchayat and Rural Development as well as the chief executive officer Jila Parishad. This court also takes note of that the presence of the standing counsel of the PNRD department was requested by this court to only inquire whether the order dated 2/8/2023 passed in WPC number 5560/2021 was complied with or not. The said exercise by this court to inquire through the standing counsel did not serve did not provide any effective result considering the above, this court therefore dispenses with the appearance of the standing counsels of the PNRD department in the present proceedings. So taking into account the statement made by Ms. Enbora, Mr. A.M. Bormia, the learned counsel appearing on behalf of the petitioner, submits that he would file appropriate application to implead the present principal secretary to the government of Assam PNRD department, as well as the chief executive officer of the Jila Parishad, the name of Ms. Enbora. The registry is directed to strike out the name of Ms. Enbora or Mr. S. Dotto as standing counsel of the PNRD from the court, from the instant proceedings.
Lordship,
It's the matter upon such application.
Lordship, there is no any post in the principal secretary now, additional chief secretary now. There is no any post in the principal secretary in the PNRD department now. Now it's additional chief secretary.
Ms. Enbora also submits that at present there is no post of principal secretary to the PNRD department. In fact, there is the post is of the additional chief secretary.
Respect of response number 1 and 3 have left. Respect of response number 2. Despite of step taken for twice, my lord, response number 4 service.
My instruction is that the respondent number already, if the respondent number 2 and respondent number 3, the SP, they have entirely submitted the documents. These are NRC related payments. As per instruction of the government, these payments are to be processed and released by the district commissioner. And everything has been placed before the district commissioner. And that is my instruction. Now the district commissioner has to take the steps for release of the fund.
So you have paid the money to the district commissioner.
Well, the bills and other documents, all related papers, that has been placed before the district commissioner. And an NRC related payment is to be made by the district commissioner. District commissioner has to take steps for release of the amount. The police headquarters or the SP, they are not the authority for making payment. I have the instructions, written instruction.
So he says that he is entitled to the 6,21,800.
But
You verified that amount.
Yes, I by that.
It is a clear admission, not. You have filed an affidavit before in the before the court, writ court,
page 18, not.
that you are going to, that you have admitted the amount of rupees 621.
And my instruction is that not rupees 359,400 plus 262,400. These have already, the papers have already been placed before the district commission.
Then why did you file an affidavit that it is admitted?
No, that's true. So
therefore, if you are admitting,
page 18, Baba,
there
page
was a
18.
direction passed in paying within 3 months. Why haven't you paid? Even was directed to whom?
No, in fact, the SP is not the authority for payment. the district commissioner has to make. And DC service is not complete on DC. Who is who pay? The district commissioner. District commissioner.
Okay. This is an application relating willful and deliberate violation to the order dated 19/9/2024, passed in deputation number 2124/2022. Whereby, upon the admission made by the respondents in the said proceedings, that a petitioner is entitled to the amount of rupees 6,21,800. The learned coordinate bench of this court directed that the payment be made within 4 months from the date of receipt of the certified copy of the order. It is also seen from a perusal of the order passed on 19/9/2024 that the respondent, the counsel for the respondent sought for 3 months, and this court granted 4 months. The certified copy of the order was duly served on 27/9/2024. Was duly served. However, as the payments were not made, the petitioner has been compelled to approach this court by filing the instant application on 28/8/2025. Almost 2 years. Almost 1.5 years, 18 months have passed by. From the date fixed by this court for due compliance to the directions passed by this court on 19/9/2024. But no payment has been made. Under such circumstances, this court therefore attaches the head of account of this head of the salary account of the district commissioner Moriga with immediate effect till the said amount of rupees 6,21,800 is not paid to the petitioner.
Logic may not.
Tomorrow,
I,
Monday, Wednesday, third, by Friday, make the payment. Otherwise, I'm going to attach. This is not done. They have to be serious.
the
The
district,
people cannot come every time out here filing a contempt.
district
You are not giving, means 6 months the court passes an order, then they will file a contempt, notice will go, years and years will happen, and thereafter things will happen. No. Let us attach this.
in fact,
And after attaching it, here, this attachment will remain till the amount is not paid.
logic,
The salary,
logic may, but this
go
notice
before the division bench, now you will realize what happened.
notice is not complete on
An
responsible.
appeal does not lie against an interim order also. There is a division bench judgment. Very
No, logic at this stage may not pass the order. But let me have the information.
Friday,
Let me have the.
Friday. This
Not-
court
not-
would
not on Friday, on
this
Monday.
court, no, Friday. No, I'm telling you, don't come up with this thing. This is not the way.
Friday, Manoj, I have some difficulty. I have some difficulty.
Ask anybody else. For the district commissioner. The district commissioner has to pay the amount. If you don't have the money, then sell off your car. The district commissioner has a car. What car does he have? Morigaon. Innova. You'll take the Innova. Take the Innova. Give him the Innova.
Well, I'll get the information. I'll get it.
2 o'clock.
Tomorrow,
Information is 2 o'clock.
tomorrow.
2 o'clock. Not tomorrow.
We have the information because notice is not served. What action they have taken, I don't know.
What notice has not been served?
In this case.
The fact remains that everybody is aware of the fact that that is why it was filed in the year August 2025. And till now, 3 months, 4 months have almost
have passed, not only 1.5 years have passed.
Let me have the information. Let Lordship may take up tomorrow. I'll get the information. What action they have taken.
Goes to miss. This court, under such circumstances, this court was inclined to attach the salary account of the petitioner of the district commissioner, Morigao. However, at the request of Mr. Deenath, the learned senior government advocate, this court have restrained from passing such orders on the assurance that some steps would be taken, some positive steps would be taken. Fusto. List the matter again to, not tomorrow, Friday.
Friday, I have something to do.
Ask somebody else.
Some person. No, I'll appear before the court.
I'm not going to call for all this. Next time I'm telling you, I'm not going to call for any of the officers any further. Attaching is the best option. Attaching of the head of accounts would be the best.
Friday is not convenient for me, but at tomorrow. I'm ready at tomorrow.
Tomorrow at 2 p.m. Order passed.
My lord, they have verified and this is the, my lord, instruction that I have got. Probably they will have to pass a speaking order. They have communicated it to me, my lord, in the form of a detailed instruction. Whatever amount was due has been paid, but my lord, he has sought for some price escalation. That has been rejected. Probably will have to go for a press challenge, my lord, in the appropriate protocol. Procedural page 11, my lord, para 5. The order.
Madam, what was the representation? What was your representation?
Not annexed to the.
Not the next. Not the next.
Very difficult, otherwise I would have passed an order.
Maybe allowed to file a petition.
That's it, very.
So I need some more time to understand.
On 8/5/2026, when the instant contempt application was listed, it was assured by the Mr. B. Gogoi, the learned standing counsel of the learned counsel who represents the mission director, National Health Mission, that the speaking order would be passed within a week's time, and accordingly, this court fixed the matter today. However, the speaking order have not yet been passed. Rather, an instruction has been placed before him dated 19/5/2026, which do not show that there is any speaking order passed. The above, therefore, shows that there is no Why are you saying about the speaking order?
My lord,
To
I-
consider and dispose of the return made in accordance within 1 month.
My lord, it will be passed by tomorrow, my lord. All these things will have to be put in the speaking order. Instead of that, my lord, they communicated to me. They verified, my lord. This is the, my lord, ground for my lord election. Instead of passing a speaking order, the form of instruction.
Speaking order would be passed.
By tomorrow, my lord.
And accordingly, this court fix the matter to do. However, neither any speaking order has been passed, nor they mentioned that the representation, what steps have been taken for disposal of the representation dated 21/1/2025 have been mentioned in the instruction provided to Mr. Bugui. The above therefore appears to be not, appears to be contrary to the directions passed by the court dated 17/3/2025 in WPC number 1448/2025. Mr. Bigogoi, the learned counsel, submits that by tomorrow, the representation of the petitioner would be disposed and informed to the petitioner. Considering the said, list this matter on Friday.
Wait, being on the from BPS Sharma, he's not well today, my lord. He presently content.
What is this matter, Mr. Guya?
This is with regard to, my lord, the judgment and order dated 14/7/25, my lord. Non-payment of
And the
bills.
direction to pay 63,09,595
Yes.
within 45 days from the receipt of the certified copy of the money. When did they receive it?
Yes, representations are there, my lord.
38/2025.
Yes.
So 38/2025, they received it. 45 days is long over. So therefore you file this case.
Yes.
And till date, they have not paid the amount.
No.
Who are the persons?
These are, my lord, respondent number 1 and 2, my lord.
Who is the respondent?
This is Commission
Tourism Department.
Secretary and Director of Tourism,
Direction is given to whom? Tourism Department.
Tourism Department. my lord.
1, 2, and 4. 4 is
Four
Director of
office
Tourism.
is not in existence now.
Huh?
4 office is not in existence now, my lord. That is the abolition.
1 and 2.
1 and 2. my lord.
Chalo.
2 offices has been abolished. Principal Secretary. is not there. 1 and 2.
Have they received the papers? Service is complete.
Service is over.
Matters come up for the first time.
Yes.
Yes, why payment has not been made? 45 days is long over. Okay, list the matter again on Friday.
Right.
List the matter on Friday.
Well, that is why I'm asking.
I'm not concerned, or ask the person concerned to appear. Ask the minister, the Commissioner of Tourism to appear. List the matter on Friday, taking into account that there appears to be an apparent violation to the directions so passed by the lower court in the bench of this court dated
14/7/20.
14/7/2025 in WPC number 7324/2013. Inasmuch as even after the expiry of more than 10 months from the date of the said order,
from the service of the certified copy of the said order, the amount of rupees 63,09,595.54 have not yet been released to the petitioner. So something is done. 882.
The exceeded amount was 12,05,874.
Then why 882?
In the affidavit without their admitted. In the affidavit without their admitted. Now to find the order at page 16.
Do one thing. If 882, they have filed an affidavit, we ask them to pay that entire amount, 12 lakhs, 882, and remaining take it from the salary who has signed the affidavit. I think better off. Who has filed the affidavit.
But I think it is the deputy commissioner's office.
Huh?
It is the deputy I do not represent them. It
No,
is
whoever has signed the affidavit,
Rather,
if he has given a wrong statement before this court, the best way to do it is take it from his salary. Let the state make the payment.
Is this also budget allocation is in respect of yet particular 8,42,000. Lordship may see my letter, Lordship. The letter I have received, Lordship, in my name.
Here they have changed it.
Lordship, it is from the Home and Political Department.
They say that 882 is payable against 12 lakh 5,000. Financial sanction has been granted.
Lordship.
Huh?
FOC has been sent, Lordship.
Okay. Mr. Who has given? Mr. M.
Lordship, I appear for respondent number 2.
Counsel who appears on behalf of the respondent number
I appear for respondent number 2.
2
Lordship.
submits that an amount of rupees as regards the amount of out of the amount of rupees 12 lakh 5,874. It has been found that an amount of rupees 8,82,000 is payable to the petitioner. In that regard, an FOC had already been made and submitted to the finance department for release of the said amount. Mr. A. Alia, the learned counsel appearing on behalf of the finance department submits that the said amount would be released in submits that the state of Assam has no money. Then you can't pay when no money. Submits that for the financial sanction to be granted by the finance department, at least 4 weeks is required. list the matter again on 24th of June 2026 to give an update as to whether the amount of rupees 8,82,000 have already been disbursed to the petitioner. Further to that, this court duly takes note of that the learned coordinate bench of this court passed the order on 10/6/2025 in WPC number 3870/2024. On the basis of the stand taken by the respondent number 3 at paragraph number 8 and 9 of the affidavit, wherein it was stated that the amount payable to the petitioner was rupees 12,05,874. However, it is also seen that the respondent number 2 and 7 have also endorsed the said stand by, as would appear from paragraph number 5 of the order dated 10/6/2025. Therefore, the stand which was taken by the concerned respondents in the writ petition appears to be contrary to what the present respondents, more particularly the respondent number 2, have taken, thereby reducing the amount of rupees 12,05,874. Reducing the amount from rupees 12,05,874 to rupees 8,82,000. The respondent number 2, you were there. You were respondent number 7 there. The respondent number 2, as well as the respondent number 3 and respondent number 4, are directed to file affidavits as to why a different stand is being taken in the contempt proceedings from what was taken in the writ proceedings. The affidavit be filed by all the 3 contemners on or before 22nd of June 2026. But the 3 respondents, 2, 3, and
Possible.
respondent number 2 had already appeared. Appeared? Yes. But the respondent number 1 is concerned, madam. No ID card has been returned, but some consignment report. Respondent number 2 has appeared? Appeared. This court duly takes note of the well-settled principles of law as have been held by various judgments of this court as well as by the Supreme Court, that when an award of the labor court or an industrial tribunal is put to challenge, the presiding officer of the labor court the industrial tribunal ought not to be made a party in the writ proceedings. Be that as it may, the petitioner was, in fact, such practice is deprecated by various orders. Taking into account the above, this court therefore strikes out the name of the respondent number 1. The respondent number 2 shall be the sole respondent in the instant proceedings. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties within 3 days before the registry of this court, and the registry shall, on the basis of the present order, as well as the updated memo of parties, shall make necessary changes in the cause title and update in the CIS. Gusto. Taking into account the above, the service being complete, list the matter service being complete, and there would be a requirement for the records of reference case number 1/2025. This court directs the said records are called for, and the registry shall do the needful. List the matter on 13th of August 2026 for final disposal. In the meantime, the registry shall ensure that the records are available on the dates.
Correspondent number 2, 3, and 4. Man.
What is there?
Yes, and number.
On all the responses except
This is
number
come
1.
up for orders.
Orders.
Yes, man. Notice was issued against remaining respondent.
Item number
16.
16. Who appears for respondent number 6? Service complete? Huh? Service is complete.
But so far as respondent number
Taking into account that the service is complete, list the matter for admission on 29th of May 2026.
One notice in the
My lord.
one, I could not serve notice because my lord, the name of the deputy.
there is no statement against my lord respondent number 1 in the entire petition.
Who is respondent number 1?
Union of India, my lord.
Union of India is here, na?
That's very way the party.
Why you couldn't serve Union of India?
The name of the deputy solicitor general did not mention the name
Where?
in the earlier order. Specific name, it was mentioned, therefore my lord, I could not take it.
How many deputy solicitor generals of India are there in Assam? How many? Then do you require the name? My goodness. Service, this is you don't have an urgency, na? No urgency. Okay. List the matter for admission on 3rd of June 2006. Yes, Mr. Solia.
Time.
Service complete. Respondent number 5, service is not complete. Complete. Okay, service being complete, it's the matter for admission on 25th of 29th of May 2026.
If I may pray, your lordship, can it be on 30? If I may pray, lordship, on 30?
30?
30.
30 is Saturday. So
Sorry.
you want to come?
Sorry,
But then
28th, lord.
28th is Thursday. 29. Very good. Don't give eye one. Mr. Chaudhary, what is this?
The lordship,
Huh?
my senior was
What is this eye business?
from late lord, court number 1.
You argue. Simple highway business. What do you want?
Passport ID.
After the word immediate demand, the word going to. What judgment in order? Okay. The council appearing on behalf of the applicant seeks for an accommodation.
The time will be taken after.
List the matter of 2 weeks.
Or after some.
No. Please, your lordship. Seeks for an accommodation on account of not filing of the additional. This the matter. Yes.
Your Lordship, the steps have been complete. Respondent number 3 and 4.
Service complete?
Yes, Your Lordship.
Service complete.
Yes, sir. I'm for the respondent number 1 and 2, Lordship. She was supposed to find their representative.
Service is complete or not?
Yes, Lordship.
Okay, service being complete, list the matter for admission on 29th of May 2026.
Hello.
Mr. Jain, service complete? Service being complete, list the matter for admission on 1st of June 2026. May please. Ultimate period, the last order 1 to. We have filed the affidavit in respect to this case. Primarily, they have stated that they are not pressing out the record to taking the leave of this court. We have also submitted one set of copy to the executive. What are these matters for? For contractual period. For the year. Where is your contempt application? My. See, the verification, Mr. Counsel, has to be done with your help also. Well, taking into account that the matter pertains to of the year 2021, the petitions have been filed. And thereupon, in 2024, you have filed this thing. The writ petitions were disposed of in the year 2024. Well, isn't it? What is the date of the disposal? 2022. Yes. You filed the present contempt application in the year 2024 after 1 year. Right. So therefore, this court will be exercising the jurisdiction under 215, not 12. Right. So therefore, otherwise, limitation is 1 year. But if you want this court to exercise, you are also to help them in tracing out the, taking into account that these are. Now he has categorically mentioned on the last occasion before the learned court net bench that the certain bills are not traceable. Now they will very well come up with the amount without those traceable bills. I can give them the liberty to that effect. In the meantime, we have submitted all the documents. You have submitted?
Yes, affidavit, they said they have submitted, Your Lordship.
This, they file an affidavit stating that.
No, no,
there's-
not here. Have they submitted before you?
That instruction I have to take, whether it's submitted before the authorities or not, that.
We have actually.
He has
So
given acknowledgement.
therefore, in pursuance to the order dated 1/4/2026, you have submitted.
My lord, this is the
So
acknowledgement.
therefore, give us an update.
Very well, Lord.
This is an application filed alleging willful and deliberate violation of the order dated 16/11/2022. Passed in WPC number.
It's a common order.
These applications have been filed. Alleging willful and deliberate violation to the judgment order dated 16/11/2022, passed in WPC number 7030/2021, 7145/2021, 6898/2021, and 68979/2021, 6897/2000, 6879/2021, and 7049/2021. Whereby the learned ordinate bench of this court disposed of the said petition, thereby directing the PHA department to undertake verification as to the actual work done, the material supplied, and thereupon, after verification, if it is found that the petitioner is entitled to the said amount, any amount, the said amount be paid within a period of 6 months. Full stop. The record reveals that on 1/4/2026, the learned counsel who appears on behalf of the contenders had submitted that on account of certain bills which could not be traced out, the verification could not be completed. Mr. So-and-so, the learned counsel, Mr. P. Hazarika, the learned counsel who appears on behalf of the petitioner, submits that in pursuance to the order dated 1/4/2026, all the requisite bills have been duly served upon
The executive engineer, PhD,
the executive engineer, PHA, Sipsagar. Taking into account the above, this court finds there to be no further impediment for the PHA department to make the verification as regards the petitioner's entitlement. List this matter again on 25th of June 2026, on which date the contender shall apprise this court as to whether the verification have been completed or not, and if so, what is the amount payable to the petitioner.
Well, there's one small issue here, Lordship. In the affidavit, we have stated that in some of the bills, there is no signature by the executive officer or the accounts officer, Lordship.
You know what to do. You can very well reject. Do you want this court to do that? Then
Obliged.
58 to kill. 58. 58. Oh, 58 withdrawn, no? 58.
Lordship, we do not take selection respondent number 3 due to inadvertent discrepancy in the order, Lordship.
Have you taken steps or not?
Lordship, inadvertent discrepancy in the order, Lordship.
What
Respondent
are
number 3, acted as district commissioner, where respondent number 3.
Huh?
Number, my lord, is order.
The work was completed in all respect which was demanded. R.R. Gogoi, the learned demand, PHA accepts notice on behalf of respondent one and two. What is the inadvertent error?
Lordship, in the order, the respondent number 3 is reflected as district commissioner, Lordship. Whereas the respondent number 3 is tourism.
Huh?
My lord, may I see this order?
Respondent number, the service of notice be taken by registered post.
Yes, Lordship, we could not take steps because the respondent number 3 is reflected as district commissioner.
But here it is Assam Tourism
Yes,
Development
Lord.
Corporation. Then how is this possible? Have you taken steps upon our ATDC?
Yes.
The counsel appearing on behalf of the petitioner submits that the petitioner have duly taken steps upon the respondent number 3. That is the Assam Tourism Development Corporation. However, in the CIS, it is shown that the respondent number 3 is the district commissioner. The registry shall make an inquiry and do the needful for aligning the cause title of the petition with that of the CIS data. And thereupon look into and therefore take a call as to whether the service have been duly taken by the petitioner. This matter again on 17th of June 2026 for an update.
I have gone through the reports again. But the one submission that I have that in the arbitral word is before your lordship now. They have brought it on record. There is no whisper about us. There is no whisper. In fact, in the claim number 1.
It's okay, but why will this court interfere? You file an appeal against that. There was, but 34 you cannot do that. So you have to do something else. But your basic claim lies against PMS.
But when the amount has been, the NTPC could have very well adjusted whatever is mine, whatever the value of my material, because they know they don't have the machinery. We have taken out the machinery. They know.
You have taken off the materials temporarily with an undertaking that you are going to return it back to them.
If necessary, because that was a
Not if necessary.
that was a-
There's no word of if necessary. Your undertaking was that you are going to hand it back to them and it would be subject to any claims made by SPML. That is your undertaking.
that was a condition put by them. Ultimately, like to make that we have, that was our machinery, and ultimately that amount has been recovered from us, taken from us, which is not being put. The action of the property at least.
Sir, not, there's no way out. We can do one thing, we can admit this requisition, keep it for pending for years. This is not, we can't do it. This is not a matter where best advice you should give to your client is proceed with against SPML because on the basis they have categorically said, not Indian evidence to the effect.
That may be recorded and we will even the legal.
That is the only way. Because they categorically say in that very letter
Yes,
that they have paid to SPML and SPML claimed on the basis of your machineries. Isn't it? Yes. So when it is their specific stand, so your claim is for SPML. So therefore, on the basis of that, you can make. That is the only way out. Heard Mr. D. Nath, the learned counsel appearing on behalf of the petitioner. Mr. D. Goswami appears on behalf of the respondent numbers 1, Gustav. None appears on behalf of the respondent number 2 in spite of service having been effected. The petitioner hearing is aggrieved by the communication dated 18/6 at page 82. Dated 82, page number 82, dated 18/6, 18/6/2024, issued by the AGM bracket CCD NTPC Bongaigaon, wherein in respect to the machinery belonging to the petitioner, the petitioner was asked to pay an amount of rupees 1,56,76,445. Else, the bank guarantee so submitted by the petitioner being BG number BG 0530 ILG Inter 0316 dated 6/2/2016 would be invoked. The record further reveals that the petitioner under such circumstances had to pay the said amount of rupees so and so. And it is under such circumstances the petitioner has sought for a direction upon the respondent number 1 for refund of the said amount. The brief facts which led to the filing of the present writ petition are that in respect to a work awarded to the respondent number 2 by the letter of acceptance number CS 4610-315-9-CS LOA-5101 dated 31/3/2008. The petitioner submitted its credentials as well as provided various machineries. The said work, which was awarded to the respondent number 2, was terminated on 25/11/2013. Resultantly, an arbitration proceedings was initiated by SPML against the respondent number 1. The petitioner admittedly was not a party to the said proceedings. It is also very relevant to take note of that upon request being made by the petitioner for release of its machinery, the machineries of the petitioner were released by the respondent number 1 on submission of a bank guarantee bearing number BZ Hetukoluna dated 6/2/2016, as well as an indemnity bond being submitted by the petitioner. The bank guarantee was of an amount of rupees 1,56,76,445, which was the value of the machineries of the petitioner. The record further reveals that in the arbitration proceedings between the respondent number 2 and the respondent number 1, the respondent number 2 made claims in respect to the machineries and equipments belonging to the petitioner. The petitioner, however, was never informed about the same either by the respondent number 1 or by the respondent number 2. Thereupon, the arbitral award was passed on 1/7/2020, whereby certain amounts were awarded in favor of the respondent number 2. And this amount which was awarded included the value of the machinery belonging to the petitioner. It is under such circumstances, it is further apparent from the materials on record that in the meantime, the award dated 1/7/2020 stood satisfied upon due payment being made by the respondent number 1 to the respondent number 2. Pursuant to a settlement agreement dated 28/2/2024. It is under such circumstances, as the respondent number 1 had already paid the said amount in respect to the machineries which were released to the petitioner in the year 2016. The respondent number 1 sought for, issued the communication dated 18/6/2024, thereby asking the petitioner to deposit the amount of rupees 1,56,74,445 within a period of 7 days, failing which the bank guarantee, the irrevocable unconditional bank guarantee which was submitted on bank guarantee dated 6/2/2016 submitted would be invoked. The records further reveal that the petitioner under compulsion had to pay the said amount of rupees 1,56,76,445. Being aggrieved, the petitioner therefore had approached this court. This court further takes note of that the respondents have filed the affidavit. Respondent number 1 had filed an affidavit supporting
the communication dated 18/6/2024. So in the said affidavit, the arbitral award was enclosed. And a perusal thereof also shows that the award, that the proceedings before the learned arbitrator included the claims in respect to the machineries belonging to the petitioners. The question therefore arises as to whether this court can direct the respondent number one to make further payment to the petitioner, a refund of the amount of rupees 1,56,76,445 to the petitioner. It is the opinion of this court that any directions so passed directing the respondent number one to refund the amount of rupees 1,56,76,445 could tantamount to interfering with the arbitral award. Under such circumstances, the said directions cannot. In addition to that, it is also relevant to take note of that it is the respondent number two who had made claims on the basis of the said, or on the made claims on the machineries belonging to the petitioner. And the learned arbitrator have awarded such a claim, the said claim. Considering the above, it is therefore the opinion of this court that the claim of the petitioner should be actually against the respondent number two, inasmuch as the respondent number two had already been disbursed the amount pursuant to the settlement agreement dated 28/2/2024 in respect to its claims arising out of the award dated 1/7/2020. Which included the machineries belonging to the petitioner. Having said so, Professor, in that view of the matter, the dispute therefore being primarily between the petitioner and the respondent number two, and the respondent number one, therefore, having not, and the respondent number two, this is, in that view of the matter, the dispute in question is primarily between the petitioner and the respondent number two. And under such circumstances, it is purely a civil dispute between the petitioner and the respondent number two. Now, which is a purely civil dispute between the petitioner and the respondent number two. The present proceedings is a public law remedy, and such private civil dispute between the petitioner and the respondent number two cannot be entertained. Under such circumstances, this court is therefore not inclined to entertain the instant petition.
for which the writ petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude or prejudice the petitioner to make any claims upon the respondent number 2 before a competent court, before the appropriate forum, if so advised. I therefore say that this is a Wednesday matter. What is this?
University, Assam University, the petitioner was a contractor for housekeeping lawsuit. He didn't deposit the EPF, so his contract to NSA was cancelled. Therefore, he was blacklisted. Page 33.
What is the case about?
Let's see what happened. He was a contractor applying the housekeeping employees to the university. And he didn't deposit EPF, and then we receive a notice from EPF department.
Let us see, you have blacklisted him.
Yes, doctor.
Where 16,8,000?
Page 33.
Where is that?
Page 33.
For a period of how long?
Not say no period is mentioned.
Okay, we interfere with it.
Not say probably this is what is not properly.
So we interfere with it, taking into account that a blacklisting cannot continue in eternity.
Correct.
So the period, they will stay.
No, let's say zero.
So therefore, the period, as of now, from today onwards, the blacklisting shall not survive.
In this case, not say another thing was there was a due with respect to Provident Fund. University is cleared. We have issued notice to him. He has not replied to that. On behalf of him, we have, as a principal employer, we have paid them 43 years. Therefore, let's say,
Well, we do one thing. Why should we go into all this thing? His only question is this.
Yep. We
set aside this, saying that whatever blacklisting has happened. From henceforth, there shall be no blacklisting. This order shall have no effect. Because it cannot go for none appears on behalf of the petitioner on call. Mr. Esika, the learned senior counsel, assisted by so-and-so, appears on behalf of the Assam University. What is that university? Assam University. Appears on behalf of the respondent numbers 3, 4, and 5. Union, none appears for the union. Mr. Doctor, AK Doctor, you appear. Just appear, there's nothing for you to say. Mr. AK Doctor appears for the respondent number 1. And Mr. Sikai, the senior counsel, assisted by so-and-so, appears for respondent number 2 to 5. The petitioner herein is aggrieved by the order dated 16/8/2022 issued by the respondent number 2, whereby the petitioner was blacklisted. The records reveal that though the writ petition was filed on 9/9/2022, this court had only issued notice but had not passed any interim directions. In the meantime,
as on date, the impugned order dated 16/8/2023, 22 had already been in force for more than 3 years, 9 months. Yes. This court further takes note of the contents of the impugned order dated 16/8/2022. And a perusal of the said impugned order reveals that there is no period mentioned whereby a period mentioned for which the petitioner was blacklisted from the Assam University. It is a settled principle of law that there cannot be a blacklisting in eternity, in as much as blacklisting amounts to a civil debt. Considering the above, as 3 years, 9 months have already passed by, this court is of the opinion that the said blacklisting, the impugned order dated 16/8/2022, cannot be further enlarged. Accordingly, the incident with petition stands disposed of with the following observations and directions. The impugned order dated 16/8/2022 stands interfered with effect from the date of the present judgment. The respondent authorities shall duly take note of the aforesaid aspect and record it in their books. No cost. In their records, huh? Yes, what is this? Huh?
Non-payment of contractual bills.
Non-payment of contractual bills.
That in pursuance of last order dated 30/4/2025, the respondent number 2 has sent this.
Which department?
Well, conjunction.
Okay. What do you say? Did you file the affidavit?
Yes, madam, we filed affidavit, but it's honorable court needed an extra documents instruction. That affidavit is in page number 19.
What is your stand now?
My lord, our stand is that, my lord, it has been, that committee refused to approve that administrative approval. What? Administrative approval, because it was expired, my lord. There was a direction in this case. Yes, my lord, because direction that could not be complied because of inspection of.
Where was the direction to pay? 9 lakhs? Earlier he has filed with petition.
Yes, my lord. Earlier, there is similar repetition. My lord, order is annexed. Therein. That is Timur Sharma versus the state of Assam. Another case, my lord.
Huh?
Order dated, my lord, 31/5/2023.
Where is that?
That is there.
This is some other person.
Other person, my lord, but the the work is same, divided in two parts, part one and part two. This is first part two, my lord. Now, this instant case is of part one, my lord.
But here it is verified that he is entitled to certain amount.
My lord,
How much is the amount he is verified? Because you are asking for, you say in your affidavit. I will see your affidavit. More particularly at paragraph number 5, 6. Page 21. As per the completion report in accordance with the PWD format, it was discovered that petitioner contractor completed 75% of the work in all respects, adhering to specification drawing. Accordingly, after demand, the FOC demand proposal was submitted by the divisional so-and-so, but the proposal could not be processed due to the fag end of so-and-so. Then the FOC demand proposal was again submitted by the divisional forest officer, but by the time the administrative approval expired on so-and-so, therefore the proposal could not be processed. Now the amount is, which is being moved is 16 lakhs. How much amount?
16,62,500.
Huh?
16,62,500.
How do you know that?
Under the completion certificate, I have annexed. That
Your
is
work is which one? Why there are two
Page number
different
14.
proposals? Now it is 9,99,97,000.
Page number 14.
You were given which part? Work?
part one, part two.
Part one.
Relating to part one.
Part one, kindly see page 27. The first proposal, which was requisition for FOC, was rupees for part one is 870.56. Subsequently, it became 995.97. So 997 is the amount. Then administrative approval was given. Now this has expired. So therefore, they have to take necessary steps for that. Isn't it?
My lord, in the earlier order, in page number, in para number, my lord, 6, earlier order, dated 1/5. In para number 6, it is written that after making necessary verification as regards,
No, now there is no verification required.
no, my lord, that is the problem, my lord. The thing is that on latest status verification, no proof was there regarding the execution of that. But here, my lord, in photograph, it is.
But then why did you write all these things in your affidavit?
My lord, after filing this affidavit, this is direction was given by this honorable.
Huh?
After filing this affidavit,
Shall produce the unsatisfactory field survey. Have you filed any affidavit?
Yes, my lord, earlier I filed.
No,
but
after 34/2025.
After filing 34/25, my lord, that was the last date. After that, there no date was fixed, my lord, for this case.
No. The submissions were made by
P. Hazarika
the Standing Council of the Soil Conservation
Department.
is contrary to the stand so taken in the affidavit in the opposition filed by the respondent numbers 1, 2, 3, 4, and 5, which was filed on 8th of April 2025. This court further takes note of that on 34/2025, a direction was issued upon the Soil Conservation Department to produce the unsatisfactory field status report as mentioned in the letter dated 31/3/2025 issued by the Joint Secretary to the Government of Assam Soil Conservation Department by the next date. No additional affidavit in that regard have been yet filed. Considering the above, this court grants a final opportunity to the Soil Conservation Department to bring on record the unsatisfactory field status report, which forms the basis of the submission so made by the Standing Council of the Soil Conservation Department. Additional affidavit. List this matter again on 17th of June 2026. In the meantime, the said affidavit report be brought on record by filing the additional affidavit on or before 16th of June 2026. Yes. File an additional affidavit, not like this. Mr. Hawk, what is this?
Was spend the time on planning the experience. The tender was issued on 10/9/2024. And I also not having any definitive instruction matter. What is the outcome of this matter? Whether the tender is still existence or not matter.
What remains? You did not participate.
Well, the there, I challenge this NIT measure, what they did measure. They had invited tender group of a group of work measure, a group containing 4 or 5 works measure in different districts. So continuity measure that becomes measure us the bidders measure. And moreover measure on new technology measure, a full depth reclamation FDR measure. That was introduced for the first time. And they are seeking experience 5 years. So measure being agreement the petitioner to do all the law. So the thing you will, well, now whether this tender is running or not, well, I have no definitive.
But you did not participate.
No, man.
So you missed your bus.
Well,
Yes. The prime counsel who always appears against Mr. Esmo.
I will refer to Michigan rubber and on challenging tender conditions. No stay was granted.
Had the tender been proceeded with?
That little information I want to know. It is, but
No,
24.
whatever may be, but tender, there was no stay. In the year 2024. We are in
Nothing survived, nothing
2023.
survived. Fail to have.
Now, therefore, you withdraw with liberty to file again if any tender
Yes,
is
tender
issued for
is-
staying in the points on quick. Mr. S. Hope, the learned counsel appearing on behalf of the petitioner submits that taking into account that the petitioner could not participate in view of the conditions which have been put to challenge, and there was no stay granted, the petitioner would not like to pursue with the instant petition. However, keeping the question open as regards the challenge so made by the petitioner in subsequent proceedings, if so arises, right? Taking into account the above, the instant petition stands closed on withdrawal, liberty has sought for to grant right. I'm a player.
The payment left the court, my lord. Mr. Roy is appealing for respondent 1 and 2, my lord.
Who is the paying?
Mr. S.S. Roy, my lord. He left the court, my lord, due to some of his, one of his, I had expired, my lord.
What is the matter about?
My lord, this matter pertains to MSME, my lord.
MSME? Delayed payment.
Yes, sir. The only contention, we have the lordship is that whether works contract will come up under MSME. That is the basic issue, my lord.
Affidavit reply been filed.
Yes, ma'am.
Your interest, you are an MSME, your interest will be going bounds and bounds every month.
Yes, ma'am.
So you should be happy with the delay in the petition. But the fact that whether you are an MSME or not, you are claiming as an MSME, why you are not going on?
I'm not claiming as MSME, my lord. My respondent number 3 and 4 are claiming as MSME.
And then why you are filing it here? You are challenging some award.
No, no, madam. We're not challenging the one. We're challenging the notice that has been issued by MSME, wherein the contractor had been allotted works contract. So works contract will not fall under MSME. That is the only moot issue. There are a series of judgments, my lord, wherein it has been opined that supply has to be there. It cannot be works contract. Sales and service, not sales or service, not works contract. That is the,
You are appearing for
Respondent number 3 and 4.
you. Who is one?
MSME.
MSME.
They should notice to us, madam.
So the question is whether MSME has the authority to issue notice or MSME has issued notice in respect to the facilitation center have issued notice.
Yes.
And you are challenging it here.
Yes.
Why?
So,
But they raise the dispute there. Why should this court entertain? Anyway, Mr. S.S. Roy, the counsel appearing on behalf of the respondent number 1 and 2 could not appear today on account of personal difficulties. No urgency. You are enjoying a stay. You are suffering. My lord. So your interest will accrue. You have also no problem. You have it after 2 years. There also appears to be no urgency. Accordingly, this matter on 18th of September 2026 in came out of past earlier and extended in the next day.
My lord, one thing, my lord. My lord, the same matter is pending, my lord. May we take this matter with the same subject?
Mr. Who has filed that?
Same part.
Well, we have filed it.
Same part.
The learned counsel also submits that there is another petition being WPC number 511 of so and so of which is also pending in respect to the same issue. The same petition be taken along with the present one.
Hello.
What is 516? What is this? The property? What is the case? From whom? And petitioner is not represented. Who is the petitioner's counsel? Huh? Okay, he's not represented. It's an old matter about man with 71 years. I think we should take it up on another thing. Find out, the counsel is not appearing. You seem to be interested in hearing for. Mr. S.K. Chakraborty submits that that affidavit has been filed on behalf of the respondent number 3. The same, however, is not on record. It is also seen that the petitioner is not represented by the counsel. For the ends of justice, the matter stands adjourned to be listed again on 12th of June 2026. So it is observed that taking into account that the petitioner is 71 years old, if the counsel appearing on behalf of the petitioner does not represent, this court may consider appointing a legal aid counsel or any other counsel so that the matter can be taken to its logical conclusion. You have filed affidavit? Why haven't you filed your affidavit? We impose a cost upon you, then file your affidavit. Next week. Sorry, that was a maintenance of perpetual bill, but that's when I not already filed the appeal. What department?
We have submitted the amount, my lord.
You know the consequences of admission now.
My lord,
Today in the morning,
the amount, would have
it's PWD, cultural affairs, who is to pay? What is that society? Some sort of connected to society. But approval was made by the cultural affairs people. Who? Cultural affairs people. Who issued the work order? But the work order issued by the PWD department. PWD. And why the response number 5 will pay?
my lord,
Because you see, the government has a tendency of saying that when it is a society, so we don't have anything to. They have a tendency.
we have admitted the amount, my lord, already, rest of the amount have already been paid. Only my lord, 4,98,000. Petitioner is claiming 5,99,130. We are admitting my lord, 4,98,300. No, sorry, 930. Lordship will find it page 23 of our. About it. My lord, paragraph. It starts from my lord, page 22, paragraph 6. Then my lord, admission.
Instead, the correct amount is 498,930. Okay,
My-
when are you paying it?
Lordship. 6 months.
How much?
6 months.
Who is going to pay?
My lord, respondent number 2.
On number 2 will.
We are representing my
On affidavit of paragraph number
6 and 7, my lord. 7 also we have admitted. Collect.
6. Number 6 to put.
7.
Eight. Pair number 6, na?
6, 7 also we have admitted my lord last 9 months. We have also done was for such and such. And the last line,
Pair number 6 and 7 is to put for him.
delete also.
Put for him. I told you about the spot number 2 shall pay the amount of this. Then they. Got 3 months. 6 months. 6. What is this fish market?
My lord, government was to file affidavit. We are for non-execution of order dated 6/2/24.
6 to
24.
where is the road?
Page number 62.
Page
62. Translated copy is in page 63.
62, election 9,
Yes, your lordship.
in vernacular,
No, the translated copy is in page 63.
63,
Yes,
the notice.
yes, your lordship.
It appears that you are illegally encroaching the reserved land allotted to so-and-so demand. Therefore, within 15 days of the issuance of the, so circle officer issues this letter. Now you want that this court should act as the authority for implementing the circle officer's order.
Your lordship, after this,
Thereafter, another notice was also issued on 26/12/2025. Actually, thing is that lordship, the first case, the Pintu Burman, he has some agreement with the AFTC regarding one fish market. Then lordship, he has come up with this petition that some encroachers are there, and we have already issued one, that notice, eviction notice, we have not executed. So, during pendency of. I remember, if the piece of the learned is aware of the fact, is not aware of the fact of present case for which. Have you become clever by the way for the last 9 months? Because you appeared on 2025 on that day.
that day prior to my, the problem is that here I can, here,
instructions were provided by you last instrument. Taking into account the above, the privacy. Has the demarcation been carried out?
no, there's some.
No. There is a pricing part by this court now.
Second requisition lordship would have issued notice to the those person. They have come up with the, that second requisition. They are also having one agreement with the AFTC. So this position has to be clear by the AFTC because they are having agreement with the, into common also and the second requisition.
And does AFPC file an affidavit? What I
Another IA.
for what?
First, because when I even. This agreement we could not find, Lordship. They are saying, he's saying that now the agreement is with him.
My question is, you are the cause of problem. Have you settled it out with both the parties?
Lordship, here, Lordship, this agreement we are searching, Lordship, this is of two thousand
You
nineteen.
filed your affidavit, Mr. Sharma.
Lordship, I have not filed, I need some time because this agreement we are searching, Lordship, this agreement in the record, 2009.
Ask for the original.
Lordship,
Ask for the original from them. Not here. AFDC has his office.
they don't have, he's saying that it is with him.
Why will they have? They are lawyers.
Authority.
My goodness. Settle it out. You are the root cause of problem for both. Isn't it? Now, both the petitions arise on account of there being agreements between the petitioners in both the petition with AFDC. AFDC, however, have not placed its stand on record for resolution of the present dispute. It is the opinion of this court that a stand of the AFDC is required. The managing director of the AFDC is given 15 days time from today for filing an affidavit. List this matter again on 25th of June 2026. In the meantime, the managing director of the AFDC shall file the affidavit without fail. In one of the matters, which one do you want to file? In 1151 of 2025.
Both the matters.
File affidavit in both the matters. Or a common affidavit in one of the matters. On or before 17th of June 2026, without fail.
My Lord, may I just pray for a date before 25th, 24th June,
You want when
24th June or 26th June?
24th?
I do.
Interim order, if any, passed earlier, stands extended till the next. What is the fight, Mr. Sokoloti, Mr. Kotoki?
The settlement order in favor of, in my case, respondent number.
Oh, I remember you were, Mr. Didas appeared for somebody and he's challenging Mr. Khan's settlement. On the ground that Mr. Khan, if he gets it, he's wrong. And another point is raised by which in the circumstance that point is allowed, he may also be out, then you come in. Something like that. You know, what is there? You are going to seek adjournment. Who is on late? Okay. Who is running? How many years now? Only running. And for another 2, 3 years, then we take up the matter. But your lordship, please. I have no. You are number 3. Number 2 is Mr. Das.
No, no. Actually, he was number 2. The first one rejected. The second, he, well, settlement was. Third was rejected by the government itself, and fourth, he picked.
Okay. And he was first rejected. Okay, what is your case with the photocopy?
My case, I have one dealing on 2 points. One is, one of the conditions is the tender, that the tenderer must be belong to the concerned district. That's one point.
Concerned district or neighborhood?
From the concerned district means, the tender notice was circulated, issued by the Kamrup, well, as well as circulated in the popular. Meaning thereby, what I mean that these 2 districts, concerned district means these 2 districts. And therefore they circulated the tender notice in 3 circles. Those are 3 circles within these 2 districts. And
The fishery falls in 2 districts.
Yeah.
So therefore, there were two authorities who issued. But how both authorities decided can issue a notice inviting tender?
Kamrup issued the notice. What happened?
But it also encompasses places in Borpeta.
Borpeta. Because what happened after the bifurcation of district, some fisheries is covered from 2 districts. And therefore, one is given the authority to issue the tender. And in this case, Kamrup district was. That is my first point, because he belongs to the Borpeta district. Secondly, under that notification, the federal government of Assam notification that one of the conditions is that the neighborhood certificate must be submitted from the circle office where the fishery forms. And admittedly, he submitted 3 possession certificates from a different circle office and not the certificate from his own circle. And these are 2 points from what I want. Okay,
This is your matter.
2051.
Let's hear it. Number 2. That is what time being is adjournment. Okay. Don't engage senior counsel. Who is based? Yes.
The tender notice at page 16,
Page 15. Page 16.
Yeah, it was 1/6.
1/6, yeah.
This was issued by the Deputy Commissioner Kamrup on 6/12/24. Clause number 2. Last line.
The concerned district and the neighborhood of the fishery. So the concerned district will be the district falling within the two. Now, this fishery in question is what are the ambits of this fishery?
Fishery ends at Barbeta.
Which fishery is this? Rupa, Rupna, Nandi,
Number 3B, lower part, Brahmaputra, and number 13, Rupna Jaldali.
We are concerned only with one fishery.
It's a group fishery, there are two fisheries clubbed together. Group. Number 3B, lower part, Brahmaputra, and number 13, Rupna Jaldali.
Where are you getting all this?
NIT itself,
NIT doesn't say anything more.
Yes, I
For
invited from the
settlement of number 3, lower part Brahmaputra and 13 number so and so, Assam Sada, a settlement period expired on so and so. So this is there.
This is the
Lower part Brahmaputra and 13 number. So lower part Brahmaputra, this fishery would be also mentioned out there as per rule 2 of the fishery rules of 1964 in the register.
Both.
So you therefore say that he belonging to Gwalpara,
Yes.
he is not, does not belong to the concerned district. Now next,
Because next page 17, if you look at the tender notice was circulated.
Warpeta, Nagorvera, Tenga,
Backbone. These three circle, the tender notice was circulated and
so
deputy
it may
commissioner.
come under the 3 circle officers, no? Nagorvera, Bagbor and Tenga. But interestingly, it is nothing to do with the Kamruk.
No, one of the circle is the in Kamrup.
And which DC has done it? DC Rural. DC Rural. The Rural.
The rural code, this Kamrup.
Now, it is difficult to certify does not fall under the area of Gwalpara district. The state fishery says someone boundary with Gwalpara district. So, this is given by District Commissioner Gwalpara. Annexure B.
Yes, will that connector B, my lord. This was not subsequently submitted by the ask to the government before settlement.
So by order dated 28/3/2025, we got it.
He got,
This is the impune order.
this is the,
Page 24.
yes.
So, third highest bidder was found to be not in the neighborhood of the fishery. That is Jonia Seluka. But your question was not taken into account only.
Yes.
And what about you?
Why?
As regards your bid? Can you see here in page 24? the third highest bidder was found to be not in the neighborhood of the fishery.
And
And
six
six was
invalid.
invalid.
Insufficient.
Who was the third highest bidder? You.
No, my lord, I myself four.
Okay. But, how do you know four?
Your
This is as per the bids.
No, 24, your lordship will find, page 24 itself.
But how do you know that these are the highest bidders they know? Highest bidder, the Gwalpara, what happened? Gwalpara is the first highest, second highest bidder.
You know? They are selected third,
The highest
myself
bidder
fourth.
followed by Zonia, but Zonia Salukura FCS was out.
Out.
And Bahari Reserve was order of bid quoted. But
Below-
why you're nothing in respect to you?
Third and sixth out, my lord.
Third and sixth is out.
Out.
It's okay. But you see, they are making reference to two,
Two.
that is him. Then they are making reference to Zonia Salekura
Yes.
and then to
Six.
Mr. Das client,
Task line was not mentioned here.
number 5.
No, my lord.
Huh?
Third bidder was found not, not in the neighborhood of the fishery. Six was invalid. The fourth and fifth, my lord, they
Mr. Das client is Bahari, na?
Bahari.
Bahari is 5.
Right.
So therefore, where is your consideration being taken? Your bid is not mentioned at all. But anyways. The bidder defaulter of government is the case of So your therefore question is only on this aspect. That has been taken care of and it is made on the basis of the order passed by the division bench.
My lord, I am coming to that. What happened? They relied on neighborhood certificate of 24 issued by the circle of 24. We applied before the deputy commissioner to ascertain the fact. Deputy commissioner issued the certificate. If you compare that certificate with the present deputy commissioner certificate, your lordship will find the evidence.
Where?
Your lordship kindly look at my certificate. I have annexed it at page 23. What the deputy commissioner Gwalpara saying. This is to certify that number 3 Lower Part Brahmaputra Fishery and 13 Rukuli Kolabanda Fishery does not fall under the jurisdiction of Gwalpara district. The said fishery shares common boundary 1/77 Bigawar Brahmaputra Fishery of Gwalpara district full stop. MS Golpora Fishery, property Fishery Golpora is located at a distance of 10 kilometers from the shared boundary of 177 Digbar Brahmaputra Fishery and number 3B lower part. Now, if your lordship see their certificate.
Their certificate.
They are paid at 55. As your lordship got it. See,
300 meters.
300 meter, my lord. Now, your the same circle officer now submitted a certificate, issued a certificate.
Where?
I am annexing that certificate. Just just 1 minute. Sir. At page 85, your lordship, can have a look at that. Same Matia circle officer. Goalpara. Now, your lordship compare this circle officer, Matia circle issued to us.
So this is similar to page 23.
My lord, same. And what they submitted before 24 is vast different.
And when was the notice inviting tender was issued?
My lord, that notice inviting tender was issued on 6/12/24.
So this document was, why this document was not taken 19/3/2025? Because the order was passed on 28/3.
So those are record will record, government record will, because that was submitted before the government.
So there was an earlier petition. This, let us see the judgment. What does the division bench say at page 135?
There are 25 will be, you know, neighborhood. The question is that in that case, neighborhood.
So neighborhood in the context of fishery in the only benefit involved.
So what, Mr. Kutuki, what it is being stated by the division there? Is what I was also saying that if a fishery traverses out there in Kamrup district or in Borpeta district, then barely the fact that the Kamrup district had issued a notice inviting tender, the people in living in the surroundings of the fishery, even in Borpeta or Senga, whatever it may be, can very well come within that ambit of neighborhood. Now here you say that the fishery in question does not traverse to Gwalpara. So therefore, if they are in Gwalpara, it is outside the jurisdiction of them. So the people in Gwalpara could not have exercised or applied because it does not touch Gwalpara.
Even your lordship, they relied on the certificate issued by Bhatia in 24, whereas that certificate relied by the same circle officer,
But the circle officer certificate is in late part of 2025. The reference to the circle officer certificate which you are making is at the late part of 2025. The order was passed on 28/3/2025. However, the thesis certificate dated 19/3/2025 had a value, but that was not taken into consideration.
that was submitted.
Huh?
That was submitted before the death.
You submitted that.
Oh. That was submitted.
No consideration. I mean, the what does it say? Bella 6. Page? Huh? Are you sure? You don't make it correctly, so you don't put it out there.
One.
Response number 2. 31/2026. I think that 31/2026. Yes, what do you say? Who has filed this? District Commissioner. So there is a tussle between the two district commissioners. I mean, is the vendor not the Where? Para?
There are 6.
6. Para 6 is what? Are you referring to 2051? Filed by response number 2.
One minute. Response number 1.
Response number 1 is you filed.
Page 88. If I,
Response number 1.
Page 88. 88.
Okay, para 6. Yes, para 6. Yes.
Statement made in paragraph 2 of the regulation to the following behind the capital. Stated, Fishery in question.
Oh, we need to say that. What do you say?
Can I have a look on paragraph 11?
No, wait, because Mr. Kotoki, para 24, yes, where is it? Yes.
In the case of Madam Walpura, limited. In connection with the settlement, the instance with the of the couple.
Understood, but on what basis does he say? He's not a revenue authority. You see, this has to be done under section rule 16. Oh, Fishery. The deputy commissioner with the previous sanction of the state government may by the proclamation published in the prescribed manner declare any collection of water running for fishery and no right in any vessel so declared shall be deemed to have been acquired by the public or any person either before or after the commencement except as provided. Nothing in the bill can affect any interest granted for pursuant to. So the right is of the DC to do so. The DC categorically says, why haven't you taken that into consideration? Your settlement is based upon a relevant document being not taken into consideration. We set aside. Huh? Your senior before he comes, we are setting it aside. Okay. What do you have to say? We set aside the settlement. So without taking into consideration the document of 9/3/2025, they could not have done that. We said, anything you want to say? Yeah.
My lord, mechanic will be the 2051.
Yes.
Page 23. First of all, the NIT member. NIT, the clause 2. Page 18.
Yeah.
অনুষ্ঠিত জাতিৰ বৰাক উপত্যকা মইন মহল
You don't trust the translated version of Mr. Kotoki's. You don't trust.
It's always better to read the.
I mean, I won't understand it. Because go by the translated version. And if you have contradicted that, you should have filed your translated version. So we go by this being certified by an advocate to be true.
Tender can be submitted by the property formed by the person actual fisherman of the civil class community. A mobile community of the Barak Valley, NGO or self-help group consisting of 100% fishermen. A mobile community of Barak Valley or civil class community. The tender must belong to the concerned district and neighborhood of the people. It says, my lord, concerned, of the facility, it says, communist or pillar are main because the distribution is to come up or in the first in the neighborhood. Thereafter, my lord, at page 58, is the certificate which we have relied upon.
So you mean to say that it can be in the neighborhood of that concerned district?
Fishery of the entire fishery and the neighboring area. So the judgment which the division bench judgment, the article 306 of 2021. In that case, my lord.
No. 306 is on a different line. 306 say that if there are, if a fishery in question traverses not only within a particular district, but other districts also. The area, the neighboring of those districts also can come. This is what is the meaning.
And what, for the entire regard, my lord, the certificate which we have relied upon, page 58, my.
My question is, I'm not on that.
Because this.
My question is, if the document of 9/3/2025 was raised, why did he refer to 24/4 of the circle officer when the DC has no competence?
Because this 19/3/2025, the district commissioner has no role to play as per the gadget notification. If my lord, you kindly see the gadget notification dated 18/1/2018. At page 53. That says, my lord, the neighborhood certificate has to be issued by the concerned revenue circle officer.
No, now this aspect is further vindicated by the fact that the circle officer who had issued the certificate on the basis of which you got it has later recanted out there and said that no, I go as per what the DC says.
Thus, this certificate, and if my lord may kindly says 93/25, this says that it shares a common boundary with Palpara is located at a distance of 10 kilometers, shares a common boundary with 1/77, lower Brahmaputra fishery and 3 lower part Brahmaputra fishery.
But your distance is from there 10 kilometers.
And my lord may kindly Peru's page 74 now, my lord.
Please pay attention.
This is the lease agreement which we have entered into, my lord.
The problem is you have intentionally not read the papers properly. Which affidavit you have included?
This is 74 is our affidavit.
Yeah, affidavit is, this is affidavit. 74, 74, 74. Ah, yes. What is it? The
This
last
is
page.
boundary which starts from west Palagonda to and so.
It is e-signed by this district commissioner. With the fishery league. Okay, where is it?
Boundary
Boundary.
west of East Palagonda, end of then. To Loitar in the south bank of western bank of Munabad, including Utna Brahmaputra, which is these Dobas, except some of the fishery which have been settled at Borpeta district, the Chennai or Gograbara going part of Brahmaputra to be considered as part of Brahmaputra fishery. The western boundary of the fishery, the Brahmaputra fishery, 3 feet to the line joining next to us. This is important, my lord, with a fixed pillar on the north bank of the Brahmaputra.
Mr. Khan, this does not satisfy me.
Yes, my
I am
lord.
not on those.
And
My question is, when this document of 9/3/2025 was placed before the authority, why the authority concerned didn't say that why we are not considering that?
if the records are everything is clear, let it come up next.
Why record? We have filed an affidavit. It is apparent. It is apparent you have not taken steps. You have gone a very wrong interpretation to the division bench judgment. No, you take it there. Okay, and let me write and get it in 10 minutes. 4 o'clock. My only question is, why haven't you considered 9/3/25? My question is, or is it not required on your part? When that document was placed, to the effect that it was not placed in the different. But if that document was placed, because that document is now being supported by the authority who gave him the certificate in 2024. At the end of the day, Rule 12 is for the purpose of the benefit of the neighborhood. This has a very, it's a concept of a social justice to be done to the neighborhood. So therefore, the fact remains that if at a later time if it is found that there was a fraud which is being committed in respect to the 2024 certificate, can you just shut your eyes out there? And more particularly, then if you had a problem with the DC, why didn't you verify? And if the DC's document was available, very difficult. Mr. Khan. The senior has also come to me. So he comes, I think, set aside, I think the senior can go to the question bench. Nine judges. No, not let's. Next week I'm not there. That is why you are making this submission. Huh?
Or tomorrow, man.
Tomorrow, no time. I said that you enjoy for 3 years. You only started. You fell into it. I asked you, don't allow this food to go in. Okay. Heard Mr. Escotoki, the learned counsel appearing on behalf of the petitioner in the petition number 2051 of the 2025. And Mr. Dita, the learned senior counsel, assisted by Mr. K. Mohammed, who appears on behalf of the petitioner in the petition number 188 of the 2025. Mr. S. Count appears on behalf of the lessee, who is the beneficiary of the settlement order dated 24 or 28, 28/3/2025. SOK appears as the standing counsel of the Fishery Department. The petitioners in both the petition have assailed the order dated settlement order dated 28/3/2025, by which the settlement has been granted in favor of the respondent number 15. The primary challenge to the settlements so made in favor of the respondent number 3 is on the basis of clause 2 of the notice inviting tender, which stipulates that the tenderer must belong to the concerned district and the neighborhood of the fishery. And in the case of the petitioners in both the petition, that the fishery in question, which was to be settled, which was settled in favor of the respondent number 3, falls within the districts of Kamrup Rural, Senga is Borpeta, as well as Borpeta district. The said fishery nowhere touches the boundaries in the district of Walpara. Mr. Escotoki, referring to the communication data, the certificate issued by the District Commissioner of Walpara, which is annexure B to the petition, submits that this certificate is dated 19/3/2025, wherein it is categorically mentioned that the fishery in question do not share mentioned that the respondent number 3 society is at a distance of 10 kilometers from the shared common boundary of 1/77 Digdar, Brahmaputra Fishery, and number 3, capital D, lower part Brahmaputra Fishery, and 13, Rupanjali Kolabanda Fishery. Question. He therefore submits that a perusal of the impugned order will show that though this particular document was available before the settlement authority, but the settlement authority had not taken into consideration, rather insisted upon a certificate issued by the circle officer, Matia, Revenue Circle, dated 21/8/2024. Though the respondent number 3 do not belong to the said revenue circle. Mr. Escotoki further submitted that this very circle officer at a later point of time on 28th of May 2025 have given a certificate which is akin to the contents of the certificate dated 19/3/2025. Mr. Escound, on the other hand, have submitted that the a perusal of the said certificate issued by the district Walpara dated 19/3/2025 would categorically show that the respondent number 3 that the fishery in question, which is to be settled, shares a common boundary with 1/77 Digdar Brahmaputra Fishery of Walpara district. He therefore submits that as there is a common boundary, and the respondent number 3 resides in the vicinity of the combined fishery. The respondent number 3 would otherwise, even if this certificate would have been taken into consideration, would have been entitled to settlement, having been the second highest bidder. This would have also heard Ms. S. Sukhir Dalanit, Standing Counsel of the Fishery Department, who submits that as to whether the communication dated or certificate dated 19/3/2025 have been was placed before the settlement authority prior to the settlement being carried out, prior to the impugned order, can be only traced out from the records, inasmuch as there is no reference to the settlement order in the settlement order. She therefore submits that she would like to place the said records. Considering the above, when do you want it next week? No, I am not. This is the matter on 28/5. Let him be. I probably put it out there. One, two.
Second.
No, no, no. I plan to. Should put that also. 9th of June 2026. Final disposal. Records of the settlement proceedings be produced without fee on the next.
That pertains to my lord non-payment of hire, sir.
Please. Please. Admitting the amount.
Is 28 lakhs 85.
And how much is he asking for?
First, school for 25.
Lord, I am asking for 23 lakhs 60,675, my lord. As on, my lord, 28th February 2025.
Total amount was 25 lakhs, out of which 3 lakhs.
25 lakh, they have paid you 3 lakh
3 lakhs
45,824. And the remaining is 21 lakhs 85,650. Building year. Three, four, five. Three, four, five, and 7. So. Now there is a 2% reduction.
Yes, after deducting lottery, that is the amount.
That is 21 lakhs.
Yes, yes.
The amount to 21 lakhs 85,000.
Obliging.
Your lordship, page 62 and 63. Filed by whom? Filed by the PD of block developer. And I can just start verification. Should have got it. The balance is 4 lakh 36,000. Balance, my lord, my assessment is 9 lakh something, but whatever my lord is there admitted lordship, they may pay it. And rest maybe I may go for lordship, the dispute. For that lordship, I go for, but what admitted lordship is a very precarious condition, which is by the block development officer. Who is to pay? Your problem is the block development officer says something else. Well, you have a lot of problem with the block development
Yes,
officer.
yes.
I could find one of the matters wherein the block development officer says something else. And later on inquiry by your commissioner finds something else. File an affidavit to the commissioner.
Yes, my lord. I can submit for this case also, my lord. What happened in this case, my lord?
Don't submit, you say you file an affidavit on behalf.
That I can.
Because we have to be doubly careful, taking into account that you keep on changing your stand. Please don't, whatever your some officers say, something else.
But that is why, madam, India has no clarity, my lord. Because these are MZ and Rega skills, my lord. And as per BTO's affidavit, my lord, it has only been closed, my lord. And only on that if the higher authority reopens the scheme in the MZ and Rega site,
and also provide necessary instruction to do undersign for doing the needful. That then only he can pay mine. So that authority has been already with the MORT, Ministry of Rural Development.
The first main, it will remain that we have done the work. You're not concerned who opens or gets it.
Yes, ma'am.
Fact remains that you had a team, you worked within the time and completed. On account of an inaction on the part of you to delay, and thereby you now require the rural developments, the sanction of them, who have to get it. We are not concerned with that. But I think this academic categorically says that an amount of rupees 4,36,197 is paid to the.
Yes.
File an application to the commissioner.
Right.
This courts have taken note of. In various litigations, on the basis of the certificate, on the basis of the affidavit filed by the block development officer, orders were passed by this court as well as the learned coordinate benches of this court. Pursuant to such orders being passed, the commissioner, the commissionerate of the PNRD department again challenges the state entitlement in contempt proceedings. Taking into account the experience, it is the opinion of this court that an affidavit of the commissioner PNRD be placed before this court as to whether the petitioner is entitled to the amount of 4,36,197 as have been certified and admitted by the block development officer in his affidavit. The said affidavit will list this matter on 17th of June 2026. The affidavit on behalf of the commissioner PNRD be filed on or before 15th of June 2026. So, Mazumdar, Lordship, I had a very sorry state of affairs, sad state of affairs. PNRD keeps on denying.
Lordship.
But let us end it.
Lordship.
Because tomorrow again, they keep on. We pass the order on the next day. Lordship.
Wait, please.
PMC.
That's it. Today I need some accommodation, my lord, because I'm holding the wrong file. When a petition is the same, I took the wrong brief, my lord.
The same file you brought it today, but what about your affidavit we filed almost 1 year back?
No, it's okay, my lord. There's
No instructions.
no, it's the direct instruction, my lord.
You have the instructions.
I have the instruction, my lord. There are multiple cases of regarding outstanding bills. We have written to the government to the file, the amount for the releasing of that amount.
My question is whether you admit this amount or not?
My lord,
File your affidavit.
well, let's bring that.
Mr. Asbora submits that he has already received instructions in the instant proceedings. The affidavit would be filed within a week's time. This matter again on 22nd of June 2026. In the meantime, the affidavit be filed on or before 17th of June 2026 as to whether the petitioner is entitled to the amount of 63,12,355 as has been claimed to by the petitioner or any other amount. Where is this? We are about to file affidavit in reply, Your Worship. I'm going to file an affidavit in reply, Mr. Worship. But counsel appears on behalf of the petitioner submits that the petitioner would like to file an affidavit in reply to the affidavit in opposition filed by the petitioner. Filed by the respondent. Oh, wait. What is that? Last time I have extended this period. The participated.
Worship, petitioner is out of state, Worship. Due to the illness of his
Well,
wife.
you must be knowing it. Did you participate pursuant to this? Otherwise, we are not going to further give you any further. To clarify that this court has not decided on the petition taken by the respondent authority not to allot the work to the petitioner which shall be subject to the petition. This court further grants the liberty to the to submit his bid in pursuance to the present review tender, which is being challenged, and such participation shall not prejudice the petitioner in the present. So you have to participate. That submits that both the petitions, affidavit in opposition have been filed by the PWD. So the partner, the petitioner would like to file reply. No time is there, na? That you have done there. But there is no urgency. Everything in the month of September. That was not a big concept. That will be the top. The 24th of June 2026. The petitioner is granted the liberty to file the reply on or before 17th of June 2026.
Like,
So what is your stand now? Why did you file the petition?
I filed a petition because I was saddled with some bills, madam. And I could not operate because there was an encroachment, for which I had informed them from time to time that encroachment was not
You
reviewed.
will make the payment of 31 lakhs?
No, madam, that was state, madam. Sorry, not.
Let's see. Not state, when was it state?
Not state, madam. Accordingly, I was terminated, madam, and without considering my representation, I had submitted detailed representation at page 56, madam.
Huh? There's no state.
There's no state.
So we state. Taking into account they have taken 1 year to find the affidavit. Does it take 1 year for you to find? See the predicament of Mr. Doctor. On one hand, you are not filing it. How many times you have taken time? 1, 2, And the best part is your forest department takes it here that every time a new council appears, huh? Once Mr. D. Gogoi appears, once Mr. I. Thakur appears, once again, Mr. Again D. Gogoi appears, one Mr. R. R. Gogoi appears, once again, you have appeared. What to do? Okay. Mr. I. Thakur submits that the affidavit would be filed within a week's time. Mr. M. Dr. the senior counsel appearing on behalf of the petitioner, on the other hand, submits that the petitioner is facing extreme difficulties, taking into account that there is that the respondents are taking steps for recovery of the amount of rupees 31,58,634, and there is no stay order. This court also take note of that on 15/9/2025, notice have been issued and directing the respondents to bring on record their stand by filing their affidavits. Taking today, this is the 7th adjournment sought for by the Forest Department, Assam Agricultural University, to file the affidavit. Considering the above, this court fixes this matter again on 19th of June 2026. Affidavit be filed on or before 10th of June 2026. Liberty given to the petitioner to file reply thereagainst. In the meantime, no coercive measures be taken against the petitioner on the basis of
28/8/25 order.
in respect to the recovery sought to be made of the amount of be 31,58,634 till the next date. Yep.
Let's send the application for waiting to input three days.
In the meantime, only my humble suggestion is that I may be allowed to live with electricity temporary connection. Since his specific direction was there, that's it.
Now, I have asked you a specific question. As to, on one hand, you are saying that it falls within the forest area, both of you. You are forest, he is APDCL. APDCL has not given it to him. I have asked for an affidavit from the APDCL. What is your stand? Why haven't you filed your affidavit? Right to? No, forget about that. I'm not you see that BC cannot be the basis on which BC or whatever meeting out there cannot be the basis on which you are granting an electricity in the neighborhood because your reason is as in the forest you are not providing. But the fact remains that if he is in the also in standing out there, then you have to provide or disconnect everybody. Are you willing to disconnect others? No, you disconnect others. Krishna is also similarly situated because of an intervening act from your part. Along with Mr. Bothakur's plan, it not be a reason for depriving the petitioner. Temporary. Yes, no problem. Every time. From the forest. Forest have not filed affidavit, so therefore they have lost their rights. No rights. Mr. Whatever, you keep on asking for time. Moment I see you now, that you only asking for a time. Not done. You tell your client that it is spoiling your image in the court. And before that to court number 10. Okay. This court, by an order dated 29/4/2026, had directed both the Forest Department as well as the APDCL to file an affidavit. However, no affidavit have either been filed, but have been filed by either of the departments. The petitioner was taking into account, it has been submitted that the said affidavit will be filed in a week's time. List this matter again on 8th of June 2026. In the meantime, the affidavit be filed by the respondents as directed by the order dated 29/4/2026 without fail on or before 3rd of June 2026. Hello. This matter will be through a tender for healthcare, eviction and dietary services. Now, my lord, on the last 3 occasions, my lord, the respondents have prayed for time to file affidavit. And it will not been filed in the meantime, the work will be entrusted to some other body inspected by enough of time, my lord. We may get some advantage to becomes to be hard or good. The issue was, my lord, there was a requirement of having GST and trade license to be registered in the state of Assam. For the last 7 years. For the last 7 years. In fact, your worship had also made an observation, although no interim order was passed. Your worship has made an observation on the first day that in the event the court finds that they are why will you file the affidavit? We need to stay these orders. No, we stay. We'll file it, whatever may be. When we pass an order, it seems your client is not interested.
No, they will send it.
No. How is it possible? After passing an order, when I don't pass an interim order, then you don't file the affidavit. Next time onwards, all PWD matters will file a grant a stay. What department?
Supplier directly article to the patient.
Okay, next time onwards, we pass orders. For all matters, wherever Mr. B. Bobo appears, all matters stay granted, they will be taken into account. It is not done. What does he say? Why have you incorporated 2C? Why have you? No, what is the justification of having for the last 7 years? When GST is there for only the last 8 years. Huh? What is the justification?
Justification, they say, required, nothing has been given, why 7 years? And my lord, when they have approached, my lord, by that time, my lord, in December, by 24th December, my lord, walk out of this, everything was over, my lord. Immediately after that, my lord, and I was okay. They also have come, my lord, they have any vivad against the tender court.
No, you have approached, he has approached on 17/12/2025. This court passed an order on 18/12/2025. You have issued the work order on 24/12/2020.
Date I don't know, my lord, date I don't know.
That is what he's saying. He says the work order was 24/12. So he issued on 24/12/2025. So therefore, whom have you made the work order?
This one, my lord.
Only printed?
Sri Ganesh Pedro.
Huh? Sri Ganesh Traders. Mr. Chaudhary, if you propose the work order, I think you may have to, otherwise, I think he should be made a party.
Maybe, my lord. But, my lord, my contention, your lordship, is that that requirement is not, my lord, for the purpose of to be issued, number one. Number two, my lord, in the NIT itself, there is a clause which requires that we have to open a, my lord, liaison office in Assam. So if that is there, my lord, that is contrary.
But tomorrow, I passed the order to the arbitrary, then the entire bid process would, but there are also rights in effective. Don't you think that you should be made a party?
Yes, yes.
You make him a party, then it is better. And an application and make him a party, a work order has been issued because he has not informed earlier. Otherwise, you would have done it.
Yes.
6 months thereafter, we
3 dates, my lord, they have taken time, they have not informed the court.
But Mr. Chaudhary, this hope you keep in mind whenever Mr. B will go in.
I'll do.
I'll keep in mind. Then next time, whenever I appear, because they don't file affidavit there are.
If my lord, no return models.
Sir, that is one of the prerequisites. Now, earlier prime minister case, balance of convenience and irreparable loss, plus Mr. B. The third, fourth condition is Mr. P. Gogo appeal. You are not filing it 6 months thereafter, you have been asked to file. You see, that is why I put it on an urgency. Today, till this court had granted the liberty to the respondents to bring on record their stand by filing the affidavit on or before 21/1/2026 by the order dated 18/12/2025. It was upon the assurance so given that the affidavit would be filed. This court did not pass any interim directions, save and except observing that if clause C of the 2C of the additional terms and conditions is found to be arbitrary and unreasonable, the entire bid process would be interfered with. It is also informed during the course of the hearing by Mr. B. Gogoi, the learned additional advocate general, that in the meantime, on 24/12/2025, a work order has been issued to one MS Ganesh Traders.
Sri Ganesh Pedro.
Sri Ganesh Traders. Taking into account that during the pendency of the incident with petition,
The Sri Ganesh trader have been issued the work order, comma. The said work order dated 24/12/2025 shall be subject to the outcome of the writ petition. Mr. M.K. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, submits that that the petitioner would be well advised to file an appropriate application to implead the said Sri Ganesh traders. He submits that within 5 days, the said application would be filed. The registry shall list the instant proceedings immediately upon filing of such application. Mr. B. Gogoi, the learned additional advocate general, also submits that within 1 day,
By 20 Monday, let us.
by 25/5/2025, 26, the affidavit on behalf of the respondents authorities shall be filed. First, this court hopes and expects that such commitments are adhered to. I didn't fix a date. I put it the moment you file that, it will be done. I think the last order passed in this case. What is this? Matter pertains to contractual bills. Contractual admitted. How much are you admitting? No. So you have received the instructions. Right. Oh, what has been complied with? Now, this is a subsequent petition thereafter. When did you file? This order, this type of order I passed only recently, so this was old, 21/11. So for remaining amount, he has filed. My lord, the issue is where is, my lord. After the, my lord, contractual part has been, my lord, complied with, work order has been completed. And my lord, they have also accepted that the work has been done, my lord, successfully. Can they, my lord, subsequently have a review of the rate of the, my lord, the worker? That is the issue. After even, my lord, admission of the dues, my lord, and sanction of the amount, subsequently they have, my lord, reviewed, because, my lord, in the contempt case, there was a personal appearance and the, my lord, secretary was for, my lord, annoyed. And they passed an order. So I have challenged that order, issue before your worship is, my lord, whether after, my lord, the work is complete and there being no condition in the, my lord, contract, in the contract or the, my lord, work order, that it can be reviewed in subsequently. Can the, my lord, now say that the rates were high? That is the issue, my lord. So you are only stating the order dated 30/11/2025. But you have not claiming the amount. I'm claiming the amount. No, you cannot claim the amount because the liberty is only for challenging the order, but petitioner has the liberty to approach the civil court for the remaining. True, man. So therefore, your limited prayer would be only challenging the order, but you can't get that amount. Yeah. Why not? You can't get it. Why not? Because of the fact you have to seek a review to that contempt order. Because you see that order, that is well. However, observe the dropping of the instant order shall not be made to assail the order dated ipso advice.
In addition to that, the petitioner shall also be at liberty to approach the competent civil court in permission for claiming the remaining amount. So therefore, you cannot get 3 crore 45 here. You have to go before the civil court. Now, if the period in the meantime expires, then don't.
Now, my lord, my submission before your lordship will be my lord. As I said, my lord,
That is the year, whatever may be, but if this court, unless you challenge that portion of the liberty.
true, my lord, if in the event, my lord, your lordship finds that, my lord, there are disputed questions of fact.
No, not disputed. I may very well say that the order is wrong. I may very well say that the order of changing of the 2011 may be wrong. But I cannot direct them to make the payment.
I understand, I agree to that, I agree to that.
So we'll record it then in my order that you have foregoing that receipt of that amount.
What, my lord, your lordship may say that
And
my
if you are
challenge is.
foregoing that amount, wouldn't it be a fruitless?
I'll not forgo that amount, my lord, unless your lordship says that the order is wrong. I cannot get a relief in the civil court also.
I gave you the liberty for remaining amount
By setting aside this order.
because you are to prove that this rate is actually this. They say that the rate is this. So therefore, if the rate is this particular amount, so it is for the civil court to look into it. You are to prove it that rate is actually this.
No, my lord, what I improve before lordship is to determine, my lord, whether they are under the, my lord, obligations of the, my lord, the contract. They can go for a review of the rate after, my lord, the work has been confirmed. My lord, everything has been sanctioned, the rate was earlier approved. Can they, my lord, now go for a, my lord, the review of the, my lord, rates? That is the issue, my lord. I'll implore your worship to decide that issue.
So they have asked you to make payment, supply on the basis of certain at a particular rate.
Yes, ma'am.
Where is your supply order?
On the supply order, your worship will find is 28, ma'am. And there was subsequently abstention, my lord. And so far as the approval of rate is concerned,
Yeah, where the amount, the direction given, what is the rate fixed, the supply order?
yes, ma'am. The rate was approved, I mean, well, page 26, my lord, the amount was approved and the rate was also approved. In fact, my lord, they conducted an inquiry. In that inquiry report also, it has been, my lord, clearly stated. If I may take your lordship to the, my lord, their inquiry report, on the basis of which the impugned order has been passed.
No, it has nothing to do with you. My question is, where is the supply order fixing the amount that can be rate?
The rate has been fixed, rate has been approved. Chicken order. No. You're also kindly bear with me for a minute. Page 34, my lord.
But people to the secretary issued by the sanction.
My lord.
This is the sanction amount given by him. My
In the-
question is,
In the sanction letter, my lord.
kindly see, this is done in 2021. Your supply orders were prior to that.
Supply order was first issued by around 7/3/2021. This is, my lord, 19/1/2021.
17?
17, 7/3/2020.
So this is subsequent there too.
Yes.
So obviously you have nothing. The way your supply order saying that your supply order was on 25th of February 2021.
My lord, what happened initially, my lord, they issued the order because of the COVID, my lord, the action they did, and subsequently there is, my lord, another supply order that your lordship will find. Page 36, my lord. Page 36. And that is subsequent to this approval.
And what is page 67? Page 67.
67, my lord. 67, my lord, that is a meeting they have purchased board has held them at a meeting subsequently.
So you are being paid at this rate.
My lord,
You are being paid at this rate.
here,
Page 67.
if your lordship comes to this inquiry report, my lord, they have given this particular rate, but subsequently, my lord, there is another inquiry that caused the, my lord, all the problem. That, my lord, starts at page 92. Sorry, my lord, page 100, my lord. When the order has been passed, my lord, the verification team has taken into account the report and the report, my lord,
Let's see the order date is 24/11/2000. Where is the 24/11? 24/11.
page 38.
Page 30. So here, having here which order which was being passed in pursuant statute, there was a inquiry of substitute. And in order to examine and verify this, with the date approved, is one of the 10 where the date of the date of I decree. You find your affidavit. Take the point which I launched. The respondent is sworn for appearing on behalf of the BPC. 6/4. No, 3 weeks. 2 weeks time for filing affidavit. It is seen that this is the 4th time. No affidavit has been filed by the respondents. And in fact, by the order dated 8/5/2026, this made it clear that the instant proceedings shall be disposed of purely on the basis of the materials on record if no affidavit is filed. However, for the ends of justice, one further chance is granted, subject to a cost of rupees 10,000 upon the council.
Oh, you are not be filing affidavit, nah. Okay, so you will not affidavit. Taking into account taking into account the paucity of time. The instant petition could not be disposed of today. Accordingly, list this matter again next week, Mr. Chaudhary. Next, accordingly, list this matter on 29th of May 2026. For final disposal. Purely on the basis of the contents of the petition as well as the enclosure, and without the defense of the respondents. You want to file reply? Mr. S. Uttapur appeared in behalf of the commissioner, submits that he would like to file a reply. None has appeared on behalf of the central government when a matter is called. Considering the above, you got an interim order now? Yes, have it in the next year. Next year. Above. This is the matter on 17th of August 2026. In the meantime, reply can be filed by the petitioner granted liberty to file the reply. Interim order passed earlier shall continue till the next day. Unappealed. Are you appearing for a picture? Has been submitted by Mr. Acceptable. The member council, member CDC could not appear on account of a demise of his neighbor. Accordingly, this matter on 25th of May 2026. In the meantime, the reply be filed on behalf of the petitioner. Friday? No. 25th. You got this affidavit on 7/4. Interim order passed earlier shall continue till the next. Here, what is the document of any instruction? It is how much? Point number 90. Equal 9. Equal 9. Yeah. Hopefully, so much. Yes, the system is a lot of. Now, here progresses are due to health and the right condition would not happen. Yes, file in leave application. Tonight I will file an activity. Tonight the additional advocate general submits the respondent number 2 to 5 would like to file an affidavit to establish this matter again July. in the month of, list this matter on 27th of July 2026. In the meantime, the respondent number 2 to 5 shall bring on record their stand by filing their affidavits on or before 22nd of July. 2000. Yes.
Yeah, can this matter be fixed on next Wednesday? Already on behalf of the superintendent of police, I have filed our affidavit. But we have sent for vetting the affidavit on behalf of the district magistrate. They are admitting the line.
Mr. S.R. Bundwa, appearing on behalf of the state, request for an accommodation for 1 week. List this matter again on 29th of May 2026.
Lordship,
You file affidavit, okay, will reply file?
we seek to file a reply, Your Lordship. I have received the reply today. There are certain defects in the reply. Maybe I have received the rejoinder today. There are certain defects in the rejoinder.
Okay, the reason for appearing on behalf of the petitioner submit that the reply. There are certain defects in the rejoinder so received. Affidavit in reply so received by the petitioner, so received by him. Accordingly, some more time will be granted. Taking into account the above, this matter again on July?
Before the vacation is possible.
No, we don't. On 31st of July 2026, in the meantime, the reply be filed on behalf of the respondents. Panchayat election. It to be filed by the Commissioner PNRB. The Joint Commissioner would not do, huh?
Yes, Commissioner.
I won't take into account any instructions from the Joint Commissioner also. The Commissioner PNRD. The government of Assam shall file the affidavit as to whether the petitioner is entitled to the amount of rupees 18,60,307 or any other amount as has been claimed in the instant proceedings. The said affidavit be filed on or before 17th of July 2026. This is the matter on 22nd of July 2026. Where is this, Mr. Das?
My Lord, reduction of revenue and for
I've asked for reduction of revenue.
my Lord. Sorry.
What is your interim prayer?
My Lord, interim prayer is not to insist, my Lord, for the entire area, because the time of.
Have they imposed the bill? Have they
No, we pay every year, my Lord, in installments. 4,01,000 every year.
You have not filed the affidavit, so we stay.
Yeah, man. I will place record also.
There may be, you should file your affidavit whether he is entitled or not. You don't want to file, tell us. We close it. Close your right to file appeal. Affidavit. Oh, 2 months have almost 1.5 months has gone. And the court has directed the learned court bench has observed that the interim of prayer would be considered on the next date.
Actually, there is a, I have to place the record also, because
So you don't want to file the affidavit?
a simple instruction is there, Lordship. I can place this also in that case, Lordship.
Okay, let us go by the instruction without the affidavit.
I'll put in the affidavit also, instruction.
I am informing that in connection with the
The tender document, there is a clause, Lord.
pertaining to reduction of revenue on the basis of provincial return. Return of provincial return. And if the page 12 so I'll have to obtain instruction, my lord. Secondly, my lord, each of my appearing on behalf of the AFDC, I plead before this court an instruction dated 18/5/2026. Very the said instruction is kept on record and marked with the letter X. From a perusal of the said instruction, it is seen that the petitioner at the time of submission of the tender had categorically mentioned that he had inspected the fishery in question as well as the condition of the fishery. And he would not raise any claim for any modification or revision later. Taking into account the said instruction, this court is not inclined to pass any interim directions at this stage. Mr. Aidstas, the learned counsel appearing on behalf of the petitioner, submits that he has also been provided with a copy of the said instruction. And he would obtain inputs from from the petitioner in that regard. List this matter again on 5th of June 2026. My lord, can it be on when do you want to enter it, my lord? 3rd of June, my lord. 3rd of June. I had it on 5th of June. You want it on 3rd? So there are lots of work, madam, try. No problem. You want it on 3rd? 3rd, madam. 3rd of yeah, no, yes, the party of mediation. Mediation report has come. What is the report? I was thinking of settlement. Huh?
Well, I do not have any touch with the union, but I have got one letter from two workmen, concerned workmen. They wrote a letter to the mediator that they are not agreeable with their settlement and they against their interest.
No, they have signed it out there. Prashant Agarwal signed it, Monju Borgo has signed it, with the president and respondent number 29, secretary of the year signed it.
No, I got this, that's why I'm submitting lot. I do not have any friction with their settled. I am not in touch, but these two workmen. But Okalnama was signed by all the workmen. They provided me Okalnama by all the workmen. I thought it my duty to.
That's also received the amount. Have not written.
Okay,
I don't know, but
this is better. We have it on next Tuesday. Okay. You may place it before the other judge. This one. On account of paucity of time, the matter could not be taken up. You also see that there is the mediation report submitted by the mediator. Taking into account the above, list this matter again on 26th of May 2026.
Lordship.